We're ready. Kaz, you might want to just give me a bit of a... Yeah, brilliant. I declare open this public hearing of the Senate Legal and Constitutional Affairs Legislation Committee's inquiry into the Public Interest Disclosure Amendment Review Bill 2022. I acknowledge the traditional owners of the land on which we meet and pay my respects to their elders past and present. I would also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via the web. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of the evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence. Described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground for which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. Before I proceed any further, my name's Senator Nita Green, and I'll be chairing this hearing today, but I am doing that remotely. So my colleagues, the Deputy Chair, Senator Paul Scar and Senator David Shoebridge, who are in the room, will, if we need to, gentlemen, if you could provide me any assistance. I won't be able to see the whole room. If someone needs to answer a question or jump in or wants to get the call.
It's packed, Chair. The room is absolutely packed. It's overflowing with people in attendance, Chair. Yeah. So we'll do our best. We've had to get more seats.
I just can't see the intricacies of people's facial expressions as well as you probably can, Senator Scar. So I appreciate your assistance. I really do. So we could make sure we have this hearing in a timely manner. With those formalities over, I now welcome the Australian Human Rights Commission to the committee today. Thank you for taking the time to speak with the committee. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Just before you begin, I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer and to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy. It does not preclude questions asking for explanations of policy or factual questions about when and how policies were adopted. For the Hansard record, could you please state your full name and the capacity in which you appear today?
Well, thank you, Chair, Deputy Chair and Senators. My name's Lorraine Finlay. I'm the Australian Human Rights Commissioner and I appear on behalf of the Australian Human Rights Commissioner, together with my colleague Mr Graham Edgerton.
Yes, thanks, Chair. Graham Edgerton, Deputy General Counsel at the Australian Human Rights Commission.
Thank you very much. We have a short period of time with you in the program this morning, so would you like to make a brief opening statement before we go to questions?
Yes, thank you, Chair, and thank you to the committee for the invitation to provide evidence today. It's important for a strong, transparent and accountable public service that insiders who witness wrongdoing have the confidence to report that wrongdoing so that it can be addressed. Taking a stand in relation to institutional wrongdoing can come at great personal cost. In order to provide confidence to whistleblowers to come forward, they need to have protections for their privacy, protections from legal actions that may be commenced against them, and protections against reprisals in their workplaces. The Commission supports the amendments to the Public Interest Disclosure Act proposed in this bill, which implement 21 of the 33 recommendations of the Moss report. There are other recommendations of the Moss Review, in our view, that should also form part of this package of reforms. A further set of amendments, or set of further amendments described in our written submission, focuses on making it easier for whistleblowers to get advice and help, both before they blow the whistle and afterwards. A key problem for whistleblowers in getting legal advice is that large swathes of government information comes with a protective security classification. Information may be protected, secret, or top secret. The Public Interest Disclosure Act provides that a whistleblower cannot disclose any classified information to a lawyer for the purposes of getting legal advice about making a public interest disclosure if the lawyer does not have a relevant security classification. The Commission recommends that the government publish a list of security cleared lawyers to make it easier for whistleblowers to get the advice that they need. Further, the requirement to go to a security cleared lawyer should be limited to information that is secret or top secret. This would align the Public Interest Disclosure Act with changes to public sector secrecy offences legislated in 2018. It is even harder for public servants in the Australian intelligence community to get legal advice about blowing the whistle on wrongdoing. As we have seen with a number of high-profile cases in this sector, despite disclosures having a high public interest value, the risk of prosecution is real and proper legal advice is vital. There need to be mechanisms to allow public servants to get proper advice about the disclosure of material that includes intelligence information. More generally, whistleblowers should be able to talk confidentially about the subject matter of their disclosure when seeking other advice and assistance, such as counselling as part of an employee assistance program or when getting workplace relations advice from a union. The Commission agrees with the changes in this bill that narrow the scope of disclosable conduct so that it no longer applies to personal work-related conduct. The Commission also agrees that agencies should be able to refer complaints to other agencies if they are better placed to investigate. However, once these changes are made, agencies should no longer have the ability to refuse to investigate a disclosure that meets the definition of a public interest disclosure on the basis that the agency considers that it is not sufficiently serious. Whistleblowers should also have greater ability to make a public external disclosure if agencies fail to comply with relevant time limits during the investigation process. Finally, the Commission recommends that parliamentary staff be included within the definition of public officials and be given the protection offered by the Act. This was a recommendation of the Set the Standard report into Commonwealth parliamentary workplaces. Parliamentary staff often have insider information about the workings of both government and public agencies. If they are aware of wrongdoing, they should have the same protections as other public servants for speaking out. Thank you again for the opportunity to provide evidence today, and we are happy to answer any questions.
Thank you very much. Deputy Chair, you have the call.
Thank you very much, Chair, and I'll closely watch the time to make sure others have an opportunity. I might go straight to one point which I'm interested in relation to obtaining advice from other professionals. And I think one of the issues that emerged from the deliberations of the Joint Select Committee looking at the National Anti-Corruption Commission was that whistleblowers and others who were reporting corrupt conduct are typically or can be under great strain, mental strain, with health implications, the pressure involved, the stresses in terms of what the ramifications are for them personally and their family in terms of doing the right thing to blow the whistle on conduct can put great strain on them. So my question is, in terms of expanding the ambit whereby whistleblowers, potential whistleblowers can seek advice, is there also room to consider whether or not they can also or should also be able to make disclosures to health practitioners who are giving them health advice and are therefore under obligations of confidentiality?
Potentially, Senator, and certainly that forms a key recommendation of our submission in terms of expanding the range of advice that's available to whistleblowers. We focus particularly on obtaining advice from employee assistance programs and from unions in terms of recognising that there are those impacts that you've described and there is a need to allow for broader advice to be obtained.
Okay, but that could presumably... My concern about just limiting it to employee assistance programs is someone might have been seeing a health practitioner over a period of time. They might not have accessed the employee assistance program, but they're seeking equivalent sort of assistance privately, and that should also fall within the ambit of that expansion of advice. And it's not just advice, it's also assistance with respect to support as they navigate the system, what's a very complicated system. Do you think your comments could be expanded to include that sort of avenue?
Yes, we do, Senator, for all of the reasons that you've described.
Okay. The next point I wanted to touch upon is the limiting the discretion not to investigate. And I note that there is a very broad, there's a great distance between serious on the one hand and frivolous or vexatious on the other. And frivolous or vexatious is a very, depending which way you look at it, high bar or low bar to jump in terms of improving or coming to a conclusion that something is frivolous or vexatious. So my concern in this respect, and it's informed to some extent by my experience as chair of the ACLI, Australian Commission for Law Enforcement Integrity Commission, is resources are limited, almost by definition, and some of these disclosures warrant investigation on a very urgent matter, and it seems to me from a policy perspective we need to achieve a balance in terms of making sure people are raising legitimate concerns in good faith. Those concerns are considered, but on the other hand making sure that resources are dedicated to the more serious complaints which have greater public interest ramifications. So this is sort of a question, half comment, I'll dress it up as a question. Do you understand the concern I would have that if you remove that sort of discretion that an appropriate independent decision maker might have to consider whether or not something warrants further investigation, you could be imposing an additional workload on that person which compromises their ability to deal with the more serious types allegations?
Well, certainly there is, as you said, a spectrum and a need for that type of balance. We would say, and again we address this in our written submissions, that by narrowing the definition of disclosable conduct, you go some way to addressing those concerns. And that indeed, if I refer you particularly to paragraph 91 of our written submissions, we look at the percentage of disclosures that were declined to investigate and the grounds that they were declined, which provides some context to that submission. So we would say, firstly, your point is met in part by the narrowing of that definition, but secondly also the improvement of referral mechanisms, which allows for disclosures to be appropriately referred for investigation to the place where they're best dealt with, and both of those things together we say addresses that issue.
So Ms Finlay, my problem with that response, not a problem with you making that response, which is very logical and makes sense, but my issue is I've got concerns with the exclusion of personal work-related conduct the way it's currently drafted, because it seems to me that could be considered in a very broad range what is personal work-related conduct. And in fact, in many of these cases, and this is informed to some extent by my experience as a whistleblower officer in a listed public company, there can be an intertwining of personal work-related conduct and the disclosable conduct, which is the subject of a bona fide complaint. So is another potential check and balance the establishment of a whistleblower protection authority that can actually serve as a check and balance in terms of decision makers, because it seems to me if the decision makers they're considering whether or not something is sufficiently serious to be warranted, if you've got that whistleblower protection authority sitting there as a check and balance, then the decision maker is going to be very careful before they decide that something is insufficiently serious.
Well, certainly we think that could be one element, and it does highlight one of the challenges that this committee has in that we're looking at a set of serious reforms absent the full picture of other reforms that need to happen in this area as well. So we'd certainly encourage the committee when considering these reforms to also have regard of what is to come and the need at the end of the day to end up with a framework that is complete in the way it looks at these things.
And Senator, in terms of the sort of thresholds that have got to be met at the start, one that you have identified is excluding personal work-related conduct, but there's a couple of other things that mean that there's a focus on more serious kinds of conduct coming out of this bill, and one of those is the definition of disclosable conduct. Previously, the definition was conduct engaged in by a public official that could, if proved, give reasonable grounds for disciplinary action against that public official, which is quite broad. I think the proposal here that it is now that it has to be action that would give grounds for termination, which kind of raises the seriousness. One of the other kind of gateway functions is that you also have to have an authorised officer who's been satisfied that that definition has been met before you get to the decision maker saying that it's not serious. So you've already had someone referring it to the agency saying, I think that all of these standards prima facie have been met before the agency head makes the decision that it's not sufficiently serious in the circumstances. So we were trying to balance up those various things, saying if it's got through those hurdles, maybe not sufficiently serious, doesn't need to be there. But I understand what you're saying.
Okay, thank you, Mr Edgerton. I'll leave it there, Chair, and chair the call.
Thank you very much. Senator Shoebridge, you have the call.
Oh, thanks, Chair. Going on that thread, obviously whistleblowers are quite often aggrieved with the agency's handling anyhow. So this emphasises, doesn't it, why if we're going to have serious structural reform, some of these decisions need to be made by bodies outside of or persons outside of the agency that's the subject of the complaint, doesn't it?
Yes, we'd agree with that, Senator.
And indeed, setting up these layers of internal review inside an agency, in light of the experience many whistleblowers have had with their agency, is not going to provide much comfort to them, is it?
In our view, there's a role for that, but certainly we take your point and I think you're correct.
Yeah. But one of the other issues in relation to the exclusions in the bill, and it's been picked up by a series of submissions, is the personal work-related grievances exclusions, the 29A exclusions. Quite often when a whistleblower has an issue of substance with an organisation, may think they're acting unlawfully or unethically, they can be seen by the agency as a troublemaker. And often that creates an antagonistic work relationship. Would you agree?
Yes, Senator.
Yeah. And then often that antagonistic work relationship may actually manifest itself in performance issues being raised with that employee and potentially allegations of bullying and the like. That's not an uncommon pattern, is it?
Correct.
And so if we're going to carve out personal work-related conduct in the way that's proposed in this bill, which says if adverse action that's taken in relation to personal work-related conduct is excluded from the PID Act, we have to be very careful about the boundaries, do you think?
You certainly do need to be very careful, Senator. However, we would note that reprisals are still included and covered under the amendment. So, again, it's a matter of finding that balance and taking those different factors into account.
But often the issue about management could be justified. A whistleblower may be aggrieved, may be unhappy in the workplace, it may be impacting on their work performance, it may be impacting on their relations with other staff, and there may well be, on one view, on a very narrow view, justifiable managerial responses to that. The person may be unhappy, may be turning up late, may be aggrieved in the workplace. There may be, on one narrow view, justifiable management responses to that. Which I'm sure management would say is unrelated to their whistleblower complaint. And that's actually what happens, isn't it? And so the concern that a number of witnesses have and submissions have is if we're going to have a personal work-related conduct exemption, it should be where it's solely related to that. And there's no potential for it to be even tangentially related to the whistleblower complaint, and make that test really clear. Do you support that very clear language, putting solely or some similar test in so that we ensure that whistleblowers are protected in those circumstances?
I think it does make sense to separate out matters that are workplace grievances from, substantive issues that whistleblowers are raising. So if there's some mechanism to be able to distinguish between those, so that exclusion of solely workplace-related grievances are out. But if somebody has raised an issue of substance, it is required to be considered. Makes a lot of sense.
But this is why the Moss Review spoke about solely or only. And I can't work out why that language hasn't found itself in the bill. Have you got an explanation for why that language hasn't found itself in the bill?
We don't have an explanation and wouldn't want to speculate on that, Senator.
No, but it does seem to me to be a very real concern how the bill in this regard deviates from the recommendations that came from the Moss Review. Would you agree?
We would agree, certainly there is more that could be done within the bill to more fully implement the recommendations from the Moss Review.
What we see, unless we implement it with care, this risks causing real harm and seeing whistleblowers with even less protection. And I suppose that's what concerns me. If we allow this exemption through as drafted, a whole raft of whistleblowers may actually have none of the protections under the PID Act unless they go through some torturous legal argument and are able to satisfy somebody that the adverse managerial conduct was in relation to their complaint.
And I think you've identified a really central dilemma when looking at this legislation, that by necessity there are technicalities and complexities in the way that it has to be drafted to make sure the legal framework works, but at its heart it needs to be simple and accessible and provide protections for people who are operating under very stressful situations.
Yeah, and given that there are a number of whistleblowers right now who are facing criminal prosecutions and potentially significant jail time, even where I think on anyone's view it was bona fide whistleblowing and very genuine complaints, that means whistleblowers have a heightened sense of anxiety about blowing the whistle at the moment. Would you agree?
We certainly understand the point you're making.
And if we make the legal minefield even harder to negotiate, well, that might send a chilling impact through the whistle, through the public service and those who might want to blow the whistle.
We would agree with that, but would also point to amendments that are being put forward by this bill that we say do provide greater protection, and to that extent we do support those amendments.
I was reading through all this in the last week and I was getting sort of World War I analogies. You blow the whistle and then you run through a particularly nasty minefield and hope you make it to the other side. That shouldn't be how the law operates, should it?
Again, Senator, we would agree that the practical operation of this legislation is incredibly important.
Which I suppose one of the practical solutions you put is the list of approved lawyers who have got security clearance. Before you run through a minefield, it's nice to have a map, isn't it? And that lawyer will hopefully allow for some of that mapping to be done, and I assume that's one of the reasons.
That's correct.
Could I ask you about your submission also talks about Section 67 of the PID Act and how if a lawyer has received a legal practitioner disclosure and then discloses it to any other person, I think it's on page 23, paragraph 75, that they might face up to 2 years imprisonment or a $33,000 penalty. I can imagine circumstances where a solicitor might have somebody come and see them. They're unsure about whether or not the secrecy provisions are actually activated, and they might call counsel. They might call a barrister and seek for some assistance from a barrister, and may have unwittingly, on my reading of your submission, committed an offence which might see them up for 2 years in jail by calling the barrister. Is that one potential way this could happen if the barrister's not security cleared?
I think that is one potential, Senator, and it's also one of the reasons, and we do highlight this in the written submissions, that again, there needs to be alignment between the different legislative provisions in different acts that deal with these types of situations. So we note, for example, the difference with the criminal code in relation to the way that these provisions are defined and offences are created. And again, it just highlights the need to really focus on ensuring there is alignment and consistency to make sure that the Act is focused on practical impact rather than legal technicalities.
Senator, if I could just add to that particular technical point that you'd made about disclosing to a barrister, it might be carved out with section 67(2), which says that the secrecy provision doesn't apply if the disclosure is for the purpose of providing legal advice or professional assistance. So arguably, if you've got a solicitor who's disclosing to a barrister so that they can get a professional advice about the disclosure, and it's for the purpose of ultimately providing that advice back to the whistleblower, then that secrecy offence might not apply.
Might not.
Well, that's my reading. I don't want to give legal advice.
I think that's you know, you'd hold on to that with both hands, wouldn't you, if you're the solicitor?
Question, Senator Shoebridge.
I suppose one of the things that I see as a theme through your submission is and I suppose it comes back to your initial point that our secrecy offences need systemic review because they're a mess and they're all over the place. But one of the things you speak to in a number of the recommendations is if you're going to have a criminal penalty or you're going to have an offence, it should be focused on harm rather than some technical source of where the information comes from. It should always have a harm focus. Is that how I read your submission?
Yes, Senator.
And that would be consistent with the amendments that have already been made to the general secrecy offences in the Criminal Code.
Yeah. Thanks, Chair.
Thanks, Senator Shoebridge. I just have a couple of questions before we have to move to our next witnesses. And just touching on the issue I think that all senators have raised in some sort of form, the issue around recommendations that you've made in relation to part of the reform that's ongoing around secrecy laws. I understand the Attorney General's Department is currently conducting a review of secrecy provisions. Can you just make it clear for the committee, because we'll be considering this as part of our report, what in your view are the further reforms that the PID Act should take into account in terms of the intersection with secrecy laws? So that review is ongoing at the moment, but we should be aware of the interaction between the two, I think, when forming the opinions in our report.
I think that's correct, Senator, and there are really two things to be aware of. The first is that we don't think the need for future reform should stop improvements from being made now that can be made now. Having said that, there's a need, obviously, to have regard to the next tranche of reforms and where they might go to ensure that underlying consistency and that there is at the end of the day a framework that actually works in relation to this area of law. I don't know, Mr Edgerton, if you wanted to add anything to that?
I think it's really important when you're thinking about the scope of protections for whistleblowers that you also think about the extent of obligations on public servants to keep material secret. The only reason you need the only reason you need the whistleblower protections is because people otherwise have obligations on them not to disclose particular material. Certainly there's a lot of outstanding recommendations from the Australian Law Reform Commission's review into secrecy laws back in 2009, and I guess what we're highlighting is that these two reforms have to operate together. You need to rationalise the extent of secrecy provisions while you're also thinking about protections for people who are subject to those provisions.
Okay. And the other point you raised as part of your submission that's been touched on today in your opening statement is around application to parliamentary staff of the PID Act. This is an act or a framework, I suppose, which has been set up based on department and agency structures. And why do you consider it would be appropriate for parliamentary staff? I think I'm just concerned that parliamentary staff do have a different work infrastructure and different reporting lines, and they sort of sit in a different work environment. So I just wondered if you could step that out for us, taking into consideration that there is ongoing work around the Set the Standard report, particularly recommendation 23 that's being implemented by the Minister for Finance.
Certainly. Well, we would first note, Senator, that it is a recommendation from the Set the Standard report that forms the basis of our recommendation to this committee. Yeah. But we would say in a broad sense that members of Parliament, while they do have obviously key responsibilities in relation to the Parliament, also have regular interaction with agencies and broader obligations in terms of the work that they do day to day. And it's for that reason that we think the extended protection is important, because it takes into account the full extent of the work that's done by members of Parliament and the potential for them to come into contact with disclosable conduct. So in that sense, we would note that the environment isn't entirely closed, that the Set the Standard recommendation is one that we believe should be followed. And we would also note, and I believe this is mentioned in the Law Council of Australia's submission, that in fact recently in New South Wales, protection has been extended to parliamentary staff. So it is something that there is now an example that can be followed. Okay,
thank you. That's all we have time for today, unfortunately. I'm sure we could ask you a lot more questions, but I did want to thank you for your incredibly extensive written submission. It's provided our committee with a lot of food for thought, particularly around recommendations that you've made to improve provisions in the bill. So thank you for taking time to give us evidence today and taking the time to prepare that submission.
Thank you, Senator.
Thank you. The committee now welcomes representatives from Maurice Blackburn, the Australian Lawyers Alliance and Centre for Public Integrity. And we'll just wait as there's a bit of a crossover of witnesses.
Chair, this is the problem with the time differential. You really need to get onto daylight saving up there.
Oh, sorry.
Yeah.
Don't accept that gratuitous comment, Chair. I'm taking a point of order.
Sorry, we now... No, it's actually an issue of double-sided pages rather than a daylight saving problem. Sorry, I apologise. We're now welcoming witnesses from the Australian Human Rights Law Centre, Transparency International and Centre for Governance and Public Policy at Griffith University.
I'm told that the Chair and the Deputy Chair have asked me to withdraw that about daylight saving, so, you know, I know it's an issue.
Thank you. I think we're good to go, and I think we've got some witnesses online as well. So we've got everyone at the table. Fantastic. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you please each state your full name and the capacity in which you appear today? We'll start with the witnesses at the table.
Professor AJ Brown from the Centre for Governance and Public Policy at Griffith University and also a board member of Transparency International and Transparency International Australia.
And James Shelton, I'm an advisor to Transparency International.
Thank you very much. And online?
Kieran Pender, Senior Lawyer at the Human Rights Law Centre.
Thanks for joining us, Kieran. Thank you for taking time to give evidence today. I just wanted to start by asking if any of you wanted to make an opening statement before we go to questions.
Thanks. I have an opening statement on behalf of the three of us.
Okay.
First, we wanted to thank the committee for inviting us to participate in the inquiry today. I'm joining remotely from the United States, and I thank the Secretariat for facilitating my virtual attendance. This bill is a worthwhile start, but it demonstrates that we need so much more. Even though it's intended as a first step in a larger process of whistleblowing law reform, shortcomings in this bill raise concerns about a continued piecemeal approach to whistleblower protections based on the process as announced to date. We wish to help ensure that the government and Parliament approach this vital reform task with the level of ambition needed to overhaul Australia's federal whistleblower protections into an efficient, coherent and effective regime. Recent events, I think, underscore the importance of effective whistleblowing and whistleblower protection regimes. The ongoing Robodebt Royal Commission points to what happens when public servants do not speak up or are not heard when they do speak up in the face of unethical and unlawful behaviour. Unfortunately, proposed amendments in this bill, if they are not revised before being enacted may make it less likely, not more likely, that people will have confidence to speak up and be properly protected if they do. And as members of Parliament, you would be familiar also with how often the public come to you to enable serious public interest concerns to be safely aired. Just a few weeks ago, Senator David Pocock used parliamentary privilege to air a whistleblower's concerns about environmental wrongdoing by Santos, including that an oil spill by the company led to dead dolphins, which it then conspired to cover up, allegedly. The fact that whistleblowers feel the need to speak up to parliamentarians like Senator Pocock on matters like these, rather than navigate whistleblowing channels that may be available to them under other laws, demonstrates ongoing shortcomings in Australia's whistleblowing regimes. Our whistleblowers really deserve nothing less than world-leading supports and protections to enable them to speak up, accessible remedies for repercussions they suffer, and a whistleblower protection authority to oversee and enforce these laws. There's also the need, and indeed a huge opportunity, for consistency in these provisions across the public, not-for-profit and private sectors. Presently, Australian whistleblowers face an impenetrable patchwork of protections. While parts of this bill try to begin addressing the problem, other parts would unfortunately worsen rather than rectify it. The Human Rights Law Centre, Transparency International Australia and Griffith University's Centre for Governance and Public Policy welcome the Albanese government's commitment to whistleblowing reform and the support shown by all sides of politics to reform in the past. However, we believe we have a huge opportunity to realise this commitment in a more effective way. That's why our submission calls on the committee to recommend a clear vision for comprehensive reform delivered through an enhanced whole-of-government process covering all federal whistleblowing legislation to enable this government and this parliament to deliver for Australia's whistleblowers and the public at large. We firmly believe that an enhanced approach is needed to resolve issues of the kind raised by this bill. And on behalf of our three organisations, Professor Brown and I have recently authored a roadmap for federal reform, which is appended to our submission, and we're delighted to be joined today by James Shelton, an advisor to Transparency International Australia, who is one of Australia's most important former whistleblowers, can shed important practical perspective on these issues. Thank you.
Thank you very much, Kieran, and thank you to the witnesses in the room. I'm going to kick off questions and then we'll go to other senators. And thank you for the written submissions that you made. I think they'll be incredibly useful as the committee prepares a report on what provisions in the bill might need to be amended or clarified to make sure that the object of the bill certainly is achieved. Just wanted to go to that. I guess there's been a lot of public calling for whistleblower protections to be included in legislation. Particularly Helen Haynes MP has welcomed the bill and has made the point that there should be protections in place before the NAC commences operations in mid-2023. Can you outline why whistleblower reform is urgent and long overdue, and what you want to see from this committee in terms of what provisions we should be looking at to make sure that the bill achieves that purpose?
Maybe Kieran, I'm happy to head off on that. I think that all of us, especially those of us who campaigned very hard over many decades, in fact, for the establishment of the National Anti-Corruption Commission, is very supportive of the goal of making sure that there are some improvements where possible to the relevant whistleblowing protection laws before the NAC commences. That's a worthy objective, and there are things that can be done that are proposed in this bill, which are reflected in our submission, and perhaps we don't need to spend so much time on, which will assist with the refinement of the current Public Interest Disclosure Act regime, and that's very, very welcome. I guess the key areas of concern, if you like, in terms of this bill, one is the issue of the definition and carve-out of personal work-related conduct as it's defined, because that will affect things right from the word go. The second is is the fact that there is a question over whether, in fact, even corruption whistleblowers, given that these amendments are intended to trigger protections that will help support the commencement of the National Anti-Corruption Commission, there's this question over whether corruption whistleblowers from within the public service will be fully protected directly if they blow the whistle on corruption within their agency that touches either Parliament or parliamentary staff. That's reflected in our submission. But I guess the third issue, which is the broad one, is the fact that at the moment, this is reflected in our opening statement and and the first few key points in our submission. The concern at the moment is that there needs to be a process for delivering that whole reform package in a coherent way that will be consistent, that will be transparent, that will be whole of government. And so to progress these amendments in the absence of that process being more clearly fully developed in a way that will address all of those things, and currently it's not, is the third big area of concern. So that's why we've suggested that the committee has a crucial role to play in helping helping the Parliament and the government set the agenda for that larger process, which needs to be, in our submission, somewhat larger and more enhanced than anything that we've heard from debate, and can realistically very easily be larger and more enhanced, and inconsistently with previous parliamentary inquiries and recommendations of parliamentary committees, etc.
Thanks very much. Can I go to one of the suggestions you've made around the definition of detriment? This is one of the things that's come up over a couple of submissions. The proposed changes to this definition, why is the proposed changes to this definition better than what's currently in place? And what do you think we can do to improve or clarify the understanding for public servants so that they understand what their obligations are?
I'm happy to lead off on that again, and then James, you might have something to say about the consistency issue. This is the single strongest part of the amendments as proposed by the government, which is very, very welcome. It's a broader definition of detriment that makes it explicit that not simply workplace-related conduct or employment actions are the focus of the type of detriment that whistleblowers may suffer or often do suffer, and which then will trigger remedies under protections under the Act, and which is the state in the current public interest disclosure bill. The trouble is that is the only focus of the way in which the current definition of detriment and reprisal action is defined. So there's two great things about the proposed broader definition of detriment. One is that it's broader and makes it very clear that all forms of damage, including psychological damage, damage outside the workplace, etc., are included, which sends a great message to public servants, or indeed anybody who's covered by the legislation, that there isn't a question as to what kind of detriment might trigger the protections. That's the kind of simplicity that you need, and comprehensiveness that you need to have. The other great thing about this provision is that it replicates directly the definition of detriment in the whistleblower protection sections of the Corporations Act. So it is the same as the definition of detriment that covers private sector, corporate banking, superannuation, finance, etc., employees. And that is deliberate, that was recommended, that is deliberate, that consistency has enormous value for exactly the same reasons. And I don't know whether, James, you want to chime in on that?
Yeah, thank you, Senators, and it's a pleasure to be here today. I'm here to support Professor Brown on his submission, and because I've been through the journey as a whistleblower. 11 years of my life was taken up by that, and I've come out at the end. I've got the battle scars, but I'm a reasonably happy and healthy person who's come through it. But you know, my goodness, what a battle that was, and the inconsistencies that I've seen in this submission is something that must be addressed here and must be addressed now. We can't have someone falling through the cracks who is trying to do the right thing, right? Expose wrongdoing, stop the bad guys doing whatever they're doing, and they fall through the crack because of a technicality. I mean, I didn't have any of those protections myself. You know, I had to protect and support myself through what I went through, but this is the chance and this is the time to do this right. So I strongly recommend to you this submission and some others, but consistency and making sure that whatever the whistleblower, and I can't speak for all whistleblowers, I can only speak for myself. If they're speaking up to put on the public agenda something that's criminal, corrupt, abusive, support them, help them, make them get through this, and they might come out the other side and have a better result from it. Thank you.
Thank you. I will hand the call over to the Deputy Chair. I might have some questions at the end, but I think I'll give others an opportunity. Thank you.
Thank you, Chair. And at the outset, if I can give my deep respect to Professor Brown and also to Mr Pender in relation to your advocacy in this respect. And Mr Shelton, I want to give you an elevated sense of recognition. I used to use your example in training I gave to senior executives in the listed public company I was General Counsel and Company Secretary of. And I used to point to your example as something we should all admire and follow. And I think that your contribution has made a difference, not just in an Australian context, but also in an international context, as a lot of the corruption you unveiled through your whistleblowing, a great personal cost related to corrupt practices in other countries. So I think you did a great service both to the people of Australia and the people of Southeast Asia in particular. So thank you very much for everything you've done. I want to, I've got three questions, or three areas of questions, and I want to share the call as quickly as I can. First relates to this vexed definition of personal work-related conduct, and certainly based on my experience, and Senator Shoebridge touched upon this, there is quite often an intertwining of the matter which is a disclosable, to use the language of the bill, of the Act, disclosable conduct that falls within the realm of that, but also what the potential whistleblower is going through in terms of their performance management, etc. So they might be set because they've raised concerns internally with respect to questioned issues, maybe in team meetings, etc. Maybe they're considered not to be a team player. Maybe they've got a wrong focus. They're going outside their bailiwick in terms of their roles and responsibilities. This leads to performance management issues, potential bullying, but at the same time, there are these issues relating to disclosable conduct. So I am concerned about the way that's been treated in this bill and how you draw the demarcation between something which solely relates to personal work conduct and something where there is a bona fide matter which is disclosable conduct, but it has attributes of, or it's entwined with personal work-related conduct. So how do we navigate that complicated issue?
Yeah, I mean, I'm happy to lead off on that again, and then James will be able to expand, or Kieran. I think the key concept is the one in the Moss Review where it said solely workplace-related grievances don't need to trigger the protections and the arrangements under these kinds of public interest disclosure protections. So the operative word being solely. The trouble with these, the way in which this provision has been drafted, and the trouble to a lesser degree, but still to a significant degree, with the way the Corporations Act equivalent provision has been drafted, is that that concept of solely does not come through. On a really technical analysis of the Corporations Act provision, it actually is there, but only on a very technical analysis, and it's consistently misinterpreted in the private sector, and I think ASIC and those responsible for trying to administer that will tell you that. They're constantly battling exactly the problem that you've just described, Senator Scarr, because the message that solely workplace-related grievances don't trigger the protections is lost, because anything that whiffs of a workplace-related grievance is very often either naturally, inadvertently or intentionally pushed down the wrong type of track for its resolution. The problem with this bill is that on a technical analysis, it doesn't even come through in law in my interpretation. It certainly does not come through in terms of clarity to anybody using the legislation from a corporate organisation or public sector management or employee, i.e. whistleblower perspective. And in fact, I think the more that we've looked at the provision, the more problems we've seen in it, because in effect, its legal consequence appears to be that if it wouldn't matter if it was corruption of the kind that James reported, if there was also a workplace conflict involved, which is, as you've rightly said, and in fact, we have the statistics from the research to confirm in a majority of cases, in a large majority of public interest disclosure cases, it will be. In those circumstances, then under the drafting as in this bill, not only is it highly likely that it'll be misinterpreted and pushed down the wrong track, but that in order to get it back on the right track, it has to pass an additional test of significance to the agency over and above the definition of corrupt conduct, which should already be applying if it's corrupt conduct. So in fact, in many ways, on our interpretation, it really significantly has the prospects of making life a lot worse in terms of the proper application of the scheme.
And that's my concern, Professor Brown. I just want to dig, we've got limited time, so there's a few issues I want to cover here. You raised the issue of the exemptions and how they're phrased. So perhaps just for the Hansard record, you've got this definition of disclosable conduct. You then have an exclusion of personal work-related conduct, but you then have exemptions from the exclusion of personal work-related conduct, which are conduct, and these are the words used, is of such a significant nature that it would undermine public confidence in an agency or agencies, or has other significant implications for an agency or agencies, end quote. Now, I'm looking at those words as someone who's been involved in the law since the early 90s, and I'm struggling to work out how someone in the position of a potential whistleblower, and even for that matter, someone has an official capacity to determine whether or not that exemption to the exclusion is triggered, can work out if something is of such a significant matter that it would undermine public confidence in an agency. And just to give you one example, I was thinking about this. It could well be that the leader of an organisation, the chief executive officer, is bullying staff, right, in such a way that they determine, well, I'm not going to report bad news up the chain, right? So the bad news, the information that's required, that needs to be acted on by policymakers, say Senate committees or whatever, is not percolating up through the system as it should, and that one example of bullying by someone in a senior leadership position is actually totemic of a toxic culture in the organisation, which means the culture is not, that the organisation is not operating as it should be, and that has significant public ramifications. But if you looked at it just narrowly, you could say, well, all it is a single issue of personal work-related conduct. Isn't that a reasonable exposition of why we have to be careful in terms of this definition, the exclusion and then the exemptions?
Senator, I'd say it's more than reasonable. I'd say it's 100% correct.
Okay. I want to move to my...
Senator, if I might just briefly expand on that problem and then offer a potential short-term solution. I think your example is a very good one. Another that I'm very concerned about, if you look at the explanatory notes within the proposed 29A, conduct relating to interpersonal conflict is one, and it provides including but not limited to bullying or harassment. So even though harassment, sexual harassment, harassment based on discriminatory attributes is unlawful under discrimination law, we have the very real possibility that someone reporting sexual harassment, whether a target of the conduct or a bystander, might find themselves not protected by these provisions. And so then if you go to that exemption, the conduct is of such a significant nature it would undermine public confidence, I think that will then become a very discretionary question. And so some some officials may think that a single incident of harassment within an agency has significant implications, others might not. And so it's going to be extremely difficult if this amendment is enacted for a potential whistleblower to know whether or not they're protected. I think in our submission, we provide a number of attributes that we say go to an improved definition. But I think even as a short-term measure, mirroring the current approach to personal workplace grievance carve-out in the Corporations Act is preferable to what is proposed. So we say that even the Corporations Act provision is not perfect, but it is better than what's currently proposed. And for all of the reasons we've just discussed with Senator Green, with the chair, as to the desirability of consistency, mirroring the corporations approach as a starting point and then seeking to address all of it as a comprehensive second phase of reform would be preferable to what is proposed here.
Okay, understood. I want to move quickly to my second topic, which is the utility of a whistleblower protection authority. Now, Mr. Shelton, trying to put myself in your shoes, which is very difficult to do, it seems to me that someone in your position as a potential whistleblower is standing at the entrance of an extraordinarily complicated legislative maze. Yes. And you enter that maze and there are inclusions, exclusions, defined terms, undefined terms, statutory cross-references. It's like you're trying to navigate the maze while solving a cryptic crossword puzzle. And at the same time, you've got the personal pressure of what does this mean for me professionally, financially, what does it mean for my family? And at the same time, you've got the potential threat of reprisal action, right? Yeah. So thinking about that situation, and Senator Shoebridge gave the analogy of someone having a map to guide them through a minefield, which is very evocative. And I was thinking about the potential utility of a whistleblower protection authority. It potentially can act as a guide to provide guidance in terms of navigating that maze. It can provide you support in terms of mental support, collegiate support. It can also provide you potentially with protection. So in the event that you are subject to potential reprisal action, it can actually take the lead in terms of assisting you to go to court, etc., to get remedies, because I'm not sure how an individual whistleblower could effectively translate the rights in the paper to rights in practice going to court, right, especially if you're part of a large organisation. I mean, there's just such a disparity in power. And also the mere presence of that authority, it seems to me, would act as a handbrake, a potential check and balance on the organisation in which you're, which is the subject of disclosable conduct. So I'm interested in your thought about the need for a whistleblower protection authority in that context, based on your experience.
Indeed, Senator, and I agree 100% with what you've just said, because just briefly, my experience was that there was no whistleblower protection authority. You know, I had to go and get legal advice at $600 an hour for each time I went and met the AFP or did a witness statement. When it finally went to court, I'm summoned to court to appear as a witness, and I have to wait out the front of the court and get, cross-examined by QCs for 2 days. There was no path, there was no guide. I did it all just because I was determined to get this result. A whistleblower protection authority, an independent authority that would somehow provide a guide, a way forward, a pathway on what you will experience, what's going to come up, what you will feel, what you'll experience, and provide some support services would have made the world of difference to me. It's too late for me, but for others who come after, yes, 100% there needs to be an independent whistleblower protection authority, private and public sector, that covers both.
Chair, just for your benefit, Senator Shoebridge just has a supplementary question on that question I just asked. But so if I could maintain the call, but just for Senator Shoebridge to ask his supplementary question.
Thanks, Chair.
Thanks. you will have to hand the call over soon.
Yeah, just on that, James, when you have a look at a number of whistleblowers who, I could think of a number right at the moment, whose substantive calls have proven to be correct about unlawful conduct, gross abuse of administrative powers, but they're actually, as we speak, being criminally prosecuted by this same government. Someone who's been a whistleblower yourself, does that emphasise the need to have some substantial government agency on their side?
Yes, I think it does. Having that removed from the executive government to have an independent authority make those decisions is a much better, much fairer system to have. I can't comment directly on each of those cases because I'm not across them totally, but I certainly know that if it is proven that whatever you're disclosing does stack up to be a genuine claim, then how you are then prosecuted for doing so is beyond me.
And if you think back to your mindset at the time, when you had to go out and blow the whistle, you had no institutional support, pretty much the lawyer you could afford, basically. If you'd seen at the same time in the media a bunch of other whistleblowers facing criminal prosecution and years in jail, what impact, looking back, do you think that would have had on your decisions?
Yeah, absolutely. I knew when I started out that the history of whistleblowers in Australia is not a good one, and it's getting better, and I am impressed by some of the changes that have been made in the National Anti-Corruption Commission. But yes, if you see someone who's going down a path that you're considering and the pain and suffering daily that they go through, it's most definitely going to put you off. Of course it would.
And Professor Brown, having that sort of independent authority could also be of assistance to authorised officers, etc., who are trying to make decisions with respect to how to interpret some of the provisions we've been referring to. And if it actually provides them an avenue to contact someone and get a guide as to, well, what do you think? Do you think this is something which should be pursued or not? And actually can assist them, because it can be, I imagine, very difficult for those officers who get reports of disclosable conduct to work, and it could involve people they know, people they've worked with, to know what the right thing to do is. So it could actually be an important source of advice for them and guidance for them. Is that correct?
That is correct. I mean, under the existing whistleblowing schemes, there is an agency for the PID Act, it's the Commonwealth Ombudsman, who can and does do a significant amount of that kind of work, or attempts to, within limited resources. What is very different about a Whistleblower Protection Authority concept is that it would not only support the effective administration of a scheme, if you like, as an administrative exercise, which is fundamentally what the Ombudsman does, but it would cut to the chase, if you like, in terms of having a responsibility to be the support and guide, so that to make sure that whistleblowers don't fall through the cracks, so that it isn't just an administrative maze. But even more importantly, they would be able to be part of those decisions in terms of significant government decisions that would have an adverse impact on the whistleblower. They would have a direct role in actually, where necessary, knocking those types of decisions back on track, as in terms of what's in the public interest. But even more importantly, they would set the standard for which cases are the ones that the Whistleblower Protection Authority itself will either take on in terms of either recommendations for remedies in the face of detrimental action, or indeed remedies pursued through the courts or through Fair Work Australia or whatever. So it would set the standard for what is unacceptable detrimental action, acts or omissions, what are breaches of duties to whistleblower, because it would cut to the chase by setting the standard by saying these are the ones we're going to pursue and get a result on. That helps all agencies get the message and get it right, and supports the good people in existing agencies who are already trying to do the right thing.
Exactly. Last question, Chair, my last question. Just the ambit of a potential Whistleblower Protection Authority, it seems to me, on what I've seen, that the government's proposing at the moment, I might be incorrect on this, but on the basis of what I've seen, it seems to be what they're talking about is something which is limited to the public sector, which begs the question in my mind. We have potential whistleblowers' conduct which should be the subject of of a blowing of the whistle in both the public sector, the private sector, all across civic society. Do you see a potential authority having a remit broader than just the public sector, and what's the utility of that?
I think James has already said, summarised the case for that. Kieran, you go.
Sure, I might answer that. I think it's artificial to distinguish too narrowly between different categories: public sector, private sector, non-profit. We see a lot of overlap. James's case is a good example of the overlap and intersection between public and private sector whistleblowing. We see a lot of that, and I think I'm not sure if the government has yet clarified its position, and I think we're awaiting a discussion paper which might provide greater clarity. But I think our very strong position would be that the Whistleblower Protection Authority or Commissioner needs to have jurisdiction over all federal whistleblowing laws and all federal whistleblowers. And I think we are seeing that this is the international trend. So I'm in the United States at the moment. I'm going to Washington, DC this coming week. I'm going to meet with the US equivalent. In fact, in the US, they have two whistleblower protection authorities. They have the Office of Special Counsel, which is an independent statutory body. And then within Parliament, they have the Office of Whistleblower Ombuds that helps members of Congress and senators interact, and committees interact and deal with whistleblowers. In the Netherlands, there's a House of the Whistleblowing, which I know gave evidence to the NAC Legislation Committee. In Slovakia, there's a whistleblowing office. In the UK, there's been a strong push for an Office of the Whistleblower. International best practice is moving inevitably towards a Whistleblower Protection Authority being a central part of whistleblowing schemes, and Australia risks being left behind if we don't have a Whistleblower Protection Authority operational soon.
Okay,
If
thank
I
you.
can just round off and give a
Thanks.
direct answer. Sorry, Madam Chair, direct answer to Senator Scarr's question. The Parliamentary Committee in 2017, the Joint Committee on Corporations and Financial Services, recommended for the federal government a Whistleblower Protection Authority that would enforce both public sector and private sector whistleblower protections for the reasons you say. James has just endorsed that concept. The Labor Party went to the election in 2019 promising a Whistleblower Protection Authority to implement that recommendation across both sectors. It's a key opportunity for Australia because our legal regime lends itself towards having a Whistleblower Protection Authority that can cover both sectors, because our workplace relations law at a federal level is comprehensive now and can cover both sectors, etc. That's not the situation in countries like the United States, where the whistleblower protections end up littered across perhaps 100 different pieces of legislation. We can actually go in the reverse direction and move from 5 federal whistleblowing regimes now, which we have, at least 5, and get it down into at least 1 or 2 administered and enforced by the same Whistleblower Protection Agency. And you're quite correct, in our correspondence with the government, the only indication we have so far is that the Whistleblower Protection Authority is being considered in the context of public sector reform of the public sector whistleblowing regime. And that's one of the reasons why we think that some clarity around that and some clarity about a process that will ensure that we do it properly is really critical now to establish that. Otherwise, we're going to end up going down various tracks that and this is the guts of our submission, that replicate or perpetuate a piecemeal approach rather than taking the opportunity to really do it comprehensively. Thank you, Madam Chair.
Thanks. Senator Shoebridge, I just have a follow-up and I'll hand the call to you for the remainder of the time, if that's helpful. Just on the public, the Whistleblower Authority, the government has committed to releasing for public consultation, as you say, a discussion paper on the Whistleblower Protection Commissioner or Authority as part of the second stage of reforms. Perhaps on notice, if you would, perhaps you could provide the committee with what you see are the priority issues for that sort of discussion paper to raise. What are some of the things that we're looking for? I know we've covered a lot of them now over the course of this discussion, but perhaps on notice that would be helpful. Thank you. Senator Shoebridge, you have the call.
Oh, thanks so much, Chair, and thanks to the three of you for all the work you've done and your organisations. When we're talking about a comprehensive Whistleblower Protection Commission, Mr Shelton, you might know of instances where corporate corruption and its engagement with public authorities bleeds sort of seamlessly into each other. And in fact, the conduct of a corporation which may be seeking to corrupt or improperly influence a government agency in Australia might also have a parallel with that corporation corruptly trying to influence agencies or foreign governments or the like. Do you want to speak about how hard it would be to put boundaries around a whistleblower commission if it was only dealing with public agencies?
Yeah, sure. And just to give you my example, I mean, I work for Security Proprietary Limited, a private company, majority owned by the Reserve Bank of Australia, minority owned by a British plastics firm. So I was in the commercial sector. When I went to the Federal Police, I went to them quite a few times, and they didn't act until it was on Four Corners and in The Age. But they told me they weren't going to investigate it until they received a referral. So, well, I've referred it to you several times. But when the RBA referred it, they instantly got into a slow pace. So, yes, I was stuck in that world of, I work for a private company, but we deal with central banks all around Southeast Asia and Central America and Africa. And the results are quite clear. There was serious criminal activity going on, but there is a crossover, and there must be lots of examples of that today where there's a private and public sector crossover.
And if there'd been a public sector whistleblower available to you, you might well have knocked on the door, and the answer might have been, well, thanks, Mr. Sheldon, but there's no help for you here.
Well, potentially, yeah. I guess that's always the case, and that's why when those systems fail, investigative journalists come to the fore. And you know, if it wasn't for Nick McKenzie and Richard Baker, I wouldn't be sitting here today. No one would know about it. So I prefer not to go down that path. I prefer to go down an authority that can provide you with support and assistance. But you know, it's not as easy to say that, but it's hard to do.
Could I go back to the carve-out for personal work-related conduct? Now, we had a discussion with the earlier witnesses from the Australian Human Rights Commission, and they supported ensuring that the Moss review was implemented in its own terms effectively, and pointed out, I think acknowledged that this bill is not consistent with the Moss review when it comes to that carve-out. Could I ask you, is it as simple as putting solely or only into 29A? Solely work conduct that is either or both? Is it as simple a drafting exercise as that?
Senator, if only it was. That would certainly be the major step in the right direction for both this carve-out, or it shouldn't even be described as a carve-out, but as for this filter, if you like, and the equivalent filter in the Corporations Act. Yeah. Section 31 of the PID Act has a filter on matters that are disagreements with government policy or government expenditure, and it uses the word only, and that is extremely helpful. Yeah. And I'm not aware of massive problems with the interpretation of that provision, but if there are problems, and there could well be a case on foot at the moment that raises that, then it's easy enough to be interpreted, and then it's easy enough to establish if it needs to be fixed to achieve the intention. So you're exactly right in that fundamental concept is not transmitted by what's drafted currently in our view. Well, it's nakedly not transmitted by the way in which the current provision has been drafted, nor does the term solely or only appear in the Corporations Act provisions, and that's its key problem. And I guess this is where, going back to what Mr Pender said earlier, given that the government understandably wants to try and start operationalising this filter, because it was a key recommendation of the Moss Review in this bill, then there's really two options. There's three options. One is to leave the drafting as it currently is, which is a huge mistake. Yep. The second is to fix up the wording so that it means something closer to the intention, but it would still be different to the Corporations Act and quite possibly still very confusing and difficult to interpret, in which case the government's going to have to come back to it again anyway. Or the third option, which could well be the fastest option, would be to do what Kieran already indicated, which is to simply not do what they're planning to do currently with the drafting, but simply replicate the Corporations Act provisions word for word in the PID Act as an interim exercise. Then at least they're consistent, and then we could come back, or Parliament could come back and figure out a simplified way of stating the test in both, the filter in both pieces of legislation, while it's considering how to simplify the entirety of the regimes. So that's what's led us to think that, given the time frame, the best option from a practical point of view is probably that third option, just replicate the Corporations Act provision with its own, with its own defects, but at least then they're consistent, and at least we've got another part of the whistleblowing regime that, like the definition of detriment, is at least on track for consistency, and we can keep going from there.
Well, I suppose I might go to you then, Ms. Pender. Your submission talks about a number of options. One is expressly using language that makes it clear that matters which are solely or only personal work related. That's one option. But you also talk about adopting the more precise language that's found in, I think it's part 9.4 AAA of the Corps Act. Do you want to talk us through those? Are they alternatives? Are they two sides of the same coin? Ms. Pender?
I think ideally we'd adopt all of those points. I don't think they're alternatives. I think they all go to a clearer definition. I think we need to remember that ultimately these laws need to be accessible to whistleblowers, people like James who see wrongdoing at work. And one of the first things they're going to do, particularly in the absence at the moment of a whistleblower protection authority, and in the absence and the very limited legal profession, like there's very few lawyers with expertise in private practice, and then you need to pay those lawyers. The Human Rights Law Centre is in the process of establishing a whistleblower project to provide whistleblowers with legal advice, but even then the capacity will be limited. We need these provisions to make sense to whistleblowers who pick up this act and read it. And the federal court very clearly, in a case a few years ago, condemned the PID Act for being impenetrable, bureaucratic, etc. We need to fix it. I think our submission at recommendation 5 makes a number of points. The language of solely or only, as comes through from the Moss Review, grievance, and then sort of altering the current sort of exemptions as well, as AJ says, the moment by focusing on only in that other provision in relation to policy disagreement. That seems to be working reasonably enough. The problem is that's a more complicated exercise. We agree with the government that it is extremely desirable to have some of these recommendations implemented before the NAC is operational. And so, although in a perfect world we would get this right once and for all, if that's not going to happen between now and when we ultimately this act is passed by Parliament, I think a better short-term solution is that we fix it by achieving consistency with the Corporations Act, and then we come back for phase 2 in the months ahead.
I can hear the Attorney General's Department, when we ask them about how 29A would work in practice, say, oh, you don't need to worry about that because there's a carve-out of the exclusion if the conduct is victimisation for the purposes of section 19 and 13 of the Act. I can already hear them saying that. But can you just take me through how hard it is to prove the conduct for the purposes of section 13 and 19, getting into the mind of somebody taking detrimental action?
AJ?
Certainly, and AJ might want to add to this, but I think one of the problems at the moment is that there's not a reverse onus provision. So in the Corporations Act, there's a reverse onus that makes it a lot easier for whistleblowers to prove victimisation, to prove detriment, reprisal. We don't have that in the PID Act at the moment. That is an important change. There has not been a single successful reprisal case brought in the almost 10 years of operation of the PID Act so far. The Human Rights Law Centre has looked at every single whistleblowing case in Australia ever. They very rarely succeed. There hasn't been a single successful one under the PID Act. And so if we make it harder, not easier, to qualify for these provisions, what it will mean is that whistleblowers who think they're doing the right thing as with the cases of Richard Boyle and David McBride, albeit a different context, I appreciate, but people who thought they were stepping through this complex act and they get to the other side and they find they're not protected. And whether they find themselves like David McBride and Richard Boyle on trial, or they find themselves dismissed from their employment and seeking to bring reprisal litigation, if they haven't jumped through all of these hoops in quite the right way, if their disclosure has an element of a personal grievance, as Professor Brown says, his research shows extremely clearly that is the most common type of whistleblowing blended. And I guess really the crux of our concern is this provision doesn't adequately deal with blended disclosures.
Professor Brown, one of the concerns I have is how on earth you would prove that the reprisal action taken against a whistleblower who might be sacked or demoted or have their work taken off them, how do you prove that that was taken for the reason of or for a reason that involves them whistleblowing? How do you get into the mind of the manager to prove that?
Senator Shoebridge, you're pointing to a very fundamental problem with the basic nature, the legal basis of the basic protections that are provided by the Act. This bill goes nowhere near updating those basic protections, the access to remedies. All I can do is, and there's many, many, many other fundamental issues about the nature of the protections that this bill doesn't go near. So it's not going to go near. But you're pointing to some of the consequences of this filter, workplace-related filter, being so important, and also if it's not got right, just how much worse it could make things. In terms of the fundamental issue, I just simply refer the committee to section 6, page 13 of our report on protecting Australia's whistleblower, the federal roadmap. It's one of the many fundamental issues which is not dealt with by this bill. I think what the key thing about this workplace-related conduct filter is that it's true that if it did satisfy with great difficulty the definition of reprisal, provable definition of reprisal, then yes, obviously if it was a workplace-related conduct, then it would trigger. The problems are, as Senator Scarr outlined, the fact that because these things become so mixed up in the first place, it's the classification at the beginning that determines what track it goes down, and you can't split them very often and say, well, we'll deal with the foreign bribery over here, but we'll deal with the workplace conflict over there, because the foreign bribery will be dismissed and the workplace conflict will be found substantiated and the whistleblower gets sacked legitimately, which is a very standard sort of outcome. But I guess getting back to the point, the other difficulty about this Act, and I notice the Commonwealth Ombudsman's submission even points out that they don't believe that the effect of this Act will be what the government is trying to achieve operationally, is that not only is it very unclear what that additional test of significance, if it's of such significance for the agency, then yes, it doesn't matter if it's workplace-related conflict or conduct, it'll still be back in. Not only is that really unclear and very hard to administer and is likely to lead to a lot of inconsistency, but it actually creates an additional threshold, as I was saying before, so that if there's workplace-related conduct involved and there's corruption or serious wrongdoing, maladministration involved, then for it to stay as a public interest disclosure, it effectively, it appears to me, has to satisfy this additional test of significance. So it's not any corruption that would trigger a public interest disclosure. If there's workplace-related conduct involved as well, then it would have to be corruption that is really significant for the agency. Well, that's the way that an agency some agencies would be likely to logically try and interpret it.
Mr. Sheldon, what do you think about the prospect of sitting down for hours and hours and hours with your $600 an hour lawyer as a whistleblower, working your way through this legal minefield?
Yeah, that would just be awful. I mean, I'm struggling to understand the technical detail of this myself, and I've been through a similar process, and I don't know how someone who's genuinely trying to do the right thing here can rely on a very expensive lawyer to give you advice that you'll pay your own money to. That you've probably already been sacked, so you don't have a lot of money to spare, by the way.
Yeah. This, I suppose, unpicking this problem shows the sort of deeper systemic problems in our whistleblowing laws, the absence of a reverse onus, the impossibility of understanding how they interact with secrecy laws and the like. Is this partly what informs your number one recommendation here, which is the Parliament needs to get onto this, not just leave it to the executive, but establish a select committee that helps drive this reform? Is that part of what informs your number one recommendation?
It's certainly part of it. I guess what we see here is an opportunity, really a once-in-a-lifetime opportunity for Australia and the Commonwealth Parliament to take all of the previous parliamentary committees, all of the thinking, all of the experience, different regimes, in order to do this comprehensively and systematically. And currently, although it's extremely welcome that this government has made some commitments in terms of a discussion paper on a Whistleblower Protection Authority, in terms of trying to clean up the public sector whistleblowing regime, that this is the opportunity to do the whole job properly, and it would be incredibly historic. It would be incredibly important on a world stage in terms of setting the standard for how to approach these things, and it would has a chance of completely changing the games in terms of outcomes. So the key problems, I guess, with any process that is less than a comprehensive whole of government process that is fully transparent is that it will end up just somehow falling short and continuing a piecemeal approach. When in the past, in the 2017 Parliamentary Joint Committee inquiry, the Parliament has really provided a great forum for setting the standard, for engaging with stakeholders, for setting the first principles. And it strikes me that 5 years since that report, however many years, 7 years since the Moss Review, 5 years since that report, or 6 years, getting on for 6 years, the opportunity is there for the Parliament to set that whole picture. There are other ways that the government might pursue a process that would ensure that this isn't done in a piecemeal, episodic way. And really that's up to the government, but certainly based on where we currently stand, one option, one very proven option would be a very well-resourced high-level parliamentary committee. But other things, as the Chair said, in terms of the government's already starting some work on this in terms of discussion of a Whistleblower Protection Authority, resetting that process in order to be more transparent, more explicit, to cover exactly what needs to be covered, would also start to provide that confidence.
Senator,
if I may add,
we're just getting to the end of our the time. Do you have one final question, or Mr. Pender, you wanted to add to that?
I just very briefly wanted to add, if I may, Senator, I think the discussion we've had today is indicative of the number of issues and the overlap between the public and private sector regimes. There's a statutory review of the private sector whistleblowing regimes coming up next year. And so I think the concern that Professor Brown and Mr. Shelton and I share is that if we keep going forward one at a time and then leapfrogging between these different regimes, we're going to continue to see these issues, as the discussion we've had today demonstrates. It's a really good step forward to link the definition of detriment across the two regimes. There's outstanding issues around the definition of personal grievance. We have this, as AJ said, once in a generation, once in a lifetime opportunity to do this comprehensively and to get it right. And the Attorney General has long been a champion of whistleblowing and whistleblower protections. The Attorney General chaired the parliamentary committee that led to the PIT Act, introduced the PIT Act as attorney in 2013. It's really fantastic to see the government's commitment to stronger whistleblower protections, but we need to get this right because this is the opportunity to do so.
Yeah. Oh, look, I think... Look, I'd agree with your observations that hopefully we have an attorney here who's willing to see long-term structural reform. But I think one of your key recommendations from the roadmap report was to ensure that we have a no wrong door approach to whistleblowing. And this bill seems to put a whole lot of additional wrong doors in the place. It's more like an episode in, I think it's Alice in Borderland, a sort of Korean drama, which scares the willies out of you if you go through the wrong door. this seems to be putting a whole bunch of wrong doors in the system. Well, do you agree? Mr. Pender?
I think that's a real concern, as our submission identifies, adding these additional roadblocks, particularly the complexity that we've all spoken to in relation to personal grievance, personal work-related conduct, that will make it harder, not easier, for people to blow the whistle. And as I said in my opening remarks, recent incidents such as the Robodebt Royal Commission, such as whistleblowers using members of parliament, such as Andrew Wilkie MP, such as Senator David Pocock, demonstrate the need to make it easier, not harder, to blow the whistle safely and lawfully.
Thank you. I have to leave it there, Senator Shoebridge. We've got to move on to other witnesses. Have you got any other questions?
I note the time, Chair.
Yeah, thank you very much. I appreciate that. Thank you to all of our witnesses for giving evidence today. And I think we might have just had one question on notice, and we'll get to you about how the time frame to get that back to the committee, because we do have a report that we need to draft. So we appreciate your assistance in that. I now welcome representatives from Maurice Blackburn Lawyers, the Australian Lawyers Alliance, and the Centre for Public Integrity. If somebody in the hearing room can just let me know if we have those witnesses, when we have those witnesses at the table, that would be helpful. Okay, I think we've got everyone online today. I don't think we've got anyone actually in the hearing room, so we can get going. I think we've got everyone who's joined us. Thank you very much for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you please each state your full name and the capacity in which you appear today? We might start with Maurice Blackburn and go through the list. Thank you. I'm sorry, we can't hear you. You're not on mute on our system, but you might be on yours.
Sorry, can you hear me now?
Yes, we can. Thank you.
Thanks, sorry about that. So my name's Julian Schimmel. I'm a principal lawyer with Maurice Blackburn.
Thank you. Mr. Droppett?
Good morning, Senator. Graham Droppett's my name. I'm the immediate past president of the Australian Lawyers Alliance, and I appear on behalf of the President, Genevieve Henderson.
Thank you. And the Centre for Public Integrity?
Good morning, Senator. My name is Catherine Williams. I appear in my capacity as Research Director of the Centre for Public Integrity, and I'm joined by Anthony Wheely.
Thanks very much. And thanks for joining us, Mr. Wheely. We're going to start questions shortly, but do any of you have a brief opening statement that you'd like to make to the committee?
I have a brief opening statement, if that's of assistance.
Thank you very much.
I didn't want a queue jump.
No, that's okay. We can all take our turns.
Senators, the Australian Lawyers Alliance is a national association dedicated to the interests of the rights of the individual and promoting justice and freedom. The ALA welcomes the opportunity to have input to the committee's inquiry into the bill. In particular, I join you from the lands of the Whadjuk Noongar people in Western Australia, a block from the mighty Turrbal Yerrigan River, and I pay respects to elders past and present. The ALA strongly believes that the protection of whistleblowers is essential to promoting integrity and accountability and trust in both public and non-public institutions. Many whistleblowers in the past have risked their health and their careers in acting as guardians of good governance and exposers of corruption and abuse. We all owe them an incalculable debt. The ALA's written submissions have endorsed reforms to further and protect whistleblowers, supported the creation of a whistleblower protection authority and commissioner, set out concerns as to the exclusion of those employed under the Members of Parliament Staff Act from accessing whistleblower protections under the PID Act, expressed reservations as to the definition of disclosable conduct, and identified the urgent need to resolve inconsistencies within the broader whistleblower protections framework. In my opening remarks, I wish just to highlight the fundamental need to support and protect whistleblowers. There have been references to the 2016 Moss review, but it's clear that in that review, Philip Moss identified that few respondents reported feeling well supported or confident in their public interest disclosures, and that individuals who made such disclosures reported adverse long-term health and career effects. The act of blowing the whistle often requires great courage. Support and protection must be the priority. ALA welcomes the proposed addition of access to legal advice to whistleblowers. There should never be reprisals for seeking or providing legal advice. The ALA also supports the creation of a positive duty to support whistleblowers and ongoing training and education for public officials. There must be a cultural shift in favour of protection and support. As I've mentioned, in relation to the Whistleblower Protection Authority or Commissioner, we note that in introducing the bill, the Attorney-General, the Honourable Mark Dreyfus KC, has committed to consult widely. The ALA welcomes this commitment and contends that it must be addressed urgently. In conclusion, the ALA notes that a number of royal commissions have revealed systemic abuse in aged care and disabilities, but we should not have to rely on such very expensive options to identify when things are going wrong. We are left with the thought that the failure that's identified, the failure in integrity in government decision-making identified through the Robo-Debt inquiry would have been avoided with stronger whistleblower protection. We hope that comprehensive and powerful whistleblower protections will encourage and protect those who know what is going on, who call out abuse, corruption and illegal conduct. It will make for a better and safer society. We trust our written submissions, of course, are of assistance to the committee.
Thank you very much. I can assure you that your written submissions are very helpful and have helped a lot of us frame the questions we'll be asking today. Maurice Blackburn, I think you might have had sorry, I can't see your name on the screen. Unfortunately, I'm not in the room to be able to say that. So Maurice Blackburn, did you have a opening statement?
Yes, we do. Thank you, Senator. And just for the record, Maurice Blackburn is a plaintiff law firm with 34 offices throughout all mainland states and territories. Our interest in the whistleblower issues is essentially twofold. Firstly, my colleagues in the employment and industrial law area provide advice and legal representation to whistleblowers. And secondly, in my area of practice, class actions, we seek redress for individuals and companies who have been affected by corporate misconduct. And obviously whistleblowers can be a critical way of exposing corporate misconduct, which is the first step towards seeking redress. As we noted in our submission, Maurice Blackburn congratulates the government on the development of this important bill and its ongoing commitment to improving protections for whistleblowers. In our submission, the bill represents a really positive first step in improving appropriate protections for whistleblowers, both as disclosures and also as witnesses. In our written submission, we've made a few suggestions about how the current bill might be able to be improved even more. I'm happy to talk through those in more detail a little later. These suggestions are, however, and I just wanted to emphasise that they are at the margins, and overall the provisions of the bill we think are appropriate and will make the PID Act even better. We also welcome the indications from the Attorney General during his second reading speech that the bill represents an important first step in a broader and long overdue reform agenda relating to whistleblowers. And there's a couple of areas in particular where we'd like to see consideration of further reforms. The first, and I think this was alluded to by the Australian Lawyers Alliance, in relation to tackling private sector whistleblower reforms in particular. As the Parliamentary Joint Committee noted in its 2017 report, an analysis of whistleblower protections across G20 countries in 2014 found that Australia's laws were totally lacking in the private sector. So we believe it's important that focus soon turns to whistleblower protections in the private sector. In my view, an appropriate starting point would be to revisit the 2017 PJC report and its recommendations to rationalise what we think are the inadequate and inconsistent private sector whistleblower legislation that currently exists. The second area where we'd like to see some reform is in relation to, I guess, one of the sort of consequences of information coming to light from whistleblowers, and protecting whistleblowers and providing a safe and workable process for disclosure of wrongdoing, as will exist in the public sector if the bill is passed, is critical. But when wrongdoing is exposed, often there's a victim of that conduct, someone who's been harmed in one way or another. So the next step in whistleblower reform that we'd like to see both in the public sector and in the private sector is removing the obstacles that currently exist and stand in the way of victims of misconduct being able to speak to whistleblowers and use the important information that they've revealed in litigation seeking redress for any consequences of misconduct. And we again hope that our written submission has been helpful for the committee, and happy to answer any further questions about the contents of our submission.
Thanks very much. Ms. Williams, did you have an opening statement at all?
Thank you, Chair. I might invite Anthony Wheeler KC as our chair to make that statement, if you're there, Anthony.
Mr. Wheely's just on mute at the moment, unfortunately.
Okay, if he, oh, there he goes.
There we go.
Thanks very much. And I'm sorry for barging in at the outset, Senator. I'm afraid I was wrestling with the difficulties of WebEx and came on very late in the piece, rather like a naughty schoolboy who rushes in to take his desk and sees that the teacher is not very pleased. So please do forgive me.
You're forgiven, Mr. Wheely. Thank you.
Thank you very much. Well, look, I'm pleased to say I'll be very brief in this opening statement. The Centre for Public Integrity very much appreciates the enormous research and work done by Griffith University, AJ Brown, Transparency International and Kieran Pender. And we've looked at their submissions, and we would very respectfully adopt the detail of many of those. And so in our submission, we've really confined ourselves to one point, and that is, while we welcome the Public Interest Disclosure Review Bill, we do think that there is the one reform that others have also addressed, and that is the need for an independent whistleblower protection authority. I had, as part of my post-judicial career, the opportunity to be an ICAP commissioner for a year or so, and I saw there how important it is to have a proper relationship between an anti-corruption agency and any whistleblowers who come forward with serious allegations of corruption. And I've also noticed since that time, over the last 7 or 8 years, that a number of the problems that state anti-corruption authorities have encountered is precisely that they come to the aid of whistleblowers because there is no one to give support and guidance to whistleblowers. And in so doing, they can prejudice their own independence as an anti-corruption body. And we saw that happen in Queensland with a very able lawyer, Alan McSporran, having to resign as the head of the CCC there because of a joint parliamentary committee that was critical of his espousal of a whistleblower's cause. So the point we simply make is all that highlights, now that we have a national anti-corruption body about to come into practical operation, the need for another body, an independent whistleblower protection authority that can provide that support and guidance, and also, as it were, direct the whole passage of the whistleblower's complaints without it interfering with the independence of the anti-corruption body, which may then be called upon to address whether the whistleblower's concerns reveal serious corruption or not. So that's our simple point, and we're very happy to elaborate it, but it's a simple point, and we hope that it's something that will be useful to the committee.
Thank you very much. Sorry, I'm just going to kick off questions, and I do note, like the previous witnesses, I think all of your submissions or opening statements have indicated that there's a broader discussion about other reform in this area. I do have some questions about the bill. It's really, as the chair, I'm really seeking to, put together a report that means that this bill is the best that it can be. And looking at some of the provisions that you've indicated might need to be revised or strengthened or just clarified. So that's what I'm interested in asking about today. If I can just go, firstly, note that all of your submissions support the bill and make recommendations in that way. Mr. Schimmel, in terms of Maurice Blackburn's submission, I wanted to ask you about the expanding the category of internal disclosure of first recipients to include an employer's lawyer or union representative where disclosure is for the purposes of seeking advice or assistance. Why is the expansion of this category important to do that in such a way? Is there any way we can improve or clarify that provision, or even just the advice that public servants receive about how they can go about making a claim in this way?
Well, I guess just sort of for context, obviously, if you're contemplating taking this sort of action and making a disclosure, obviously that, I think this has been noted frequently elsewhere, that, it's a fairly intimidating sort of process, complex and intimidating process. People who are considering taking that sort of action might be in situations where it's in fact a highly intimidating process to go through. Adding a union representative in particular as someone to whom the disclosure can be made, we would think that union representatives can provide that support. Someone who's in that sort of a situation and considering making this sort of a disclosure, and providing that bridge essentially between a sort of intimidating process and that information coming to light.
Okay, and your recommendation is to expand the category. I think in terms of the way it's drafted at the moment, what is it about the expansion that you think is really key to ensuring that, people are supported through this process?
Well, it's sort of altogether a fairly straightforward expansion, I think, in a fairly limited but important expansion, just to include the two categories that we've mentioned in our submission, a person's lawyer or a person's union representative.
Okay. There was another recommendation that you made around employers' liability to pay compensation. Can you just talk us through an amendment of the section, that requires an employer to establish that it took all reasonable precautions, all reasonable precautions, not just reasonable precautions, and why that's important for establishing employers' liability?
Well, so as you know, Section 14, subsection 2 contains a defence of reasonable precautions. What we'd like to see again is, as I said in my opening remarks, these are fairly sort of suggestions which are at the margins in terms of ways that we think that the bill might be improved. So what we'd like to see is that defence, it's sort of a semantic but still significant change. So that the defence is only open if the employer takes all reasonable precautions. We think that'll avoid later debate about, where, for example, an employer might have done something, might have taken some precautions, but they haven't done everything that's reasonably open to them to avoid the reprisal action. So we just want to see that effectively just tightened up, made a little bit more watertight by requiring an employee to do everything that's reasonably necessary, to take all reasonable precautions to avoid that, to avoid reprisal.
Thanks. And I think just one other provision you refer to, and it's actually been picked up by other witnesses, and I think the senators who are joining you today have a particular interest in the personal work-related conduct and the way that that is defined. In your submission, you do raise some concerns or in terms of the way that it's drafted. What would you like to see to make sure that personal work-related conduct, that carve-out is dealt in the right way? You're from the class actions section of your law firm, but I know that your law firm particularly would be dealing with people who have been unfairly treated at work, and I know there is a crossover, and we're keen to get the language right so that we deal with these in the right way.
Yeah, that's right. I think, and I caught a little bit of the end of the last session, I thought, where I think that issue was being discussed. And there's probably a few different ways that it might be able to be done. We've put forward one way to address that crossover issue, where there's not necessarily a bright line between conduct that, is only a personal work-related grievance and conduct that potentially has wider ramifications for the organisation. We've put forward a way of dealing with that, which would be to add a new section 29B, not necessarily wedded to that as the only way of sensibly dealing with it, but in our submission there does need to be a way to address conduct where, it does have a personal, it does relate personally to the individual, but does have potentially a wider, systemic or cultural or other broader consequence for the organisation. I'd note that the Corporations Act provision, which deals with a similar issue, Section 1317 AADA, puts it in a sort of a negative way that the information concerns a personal work-related grievance if it relates to the person's employment, but the information does not have significant implications for the regulated entity to which it relates. So there's sort of acknowledging the potential personal implications, but then saying where it does not have these other characteristics, then it's appropriate for it to be dealt with under the whistleblowing regime. So potentially there's other ways of dealing with it as well. But most importantly in our submission, we just want to ensure that crossover issue is appropriately dealt with in the bill.
Thank you. I appreciate that. I'm sure others will have questions. One last question from me, and then I'll hand over the call. And this is essentially, I think, for the Australian Lawyers Alliance, but also the Centre for Public Integrity. Look, there has been a flagging of other reforms, and particularly around the whistleblower authority or public agency. Can I just ask, the government has committed to releasing for public consultation a discussion paper on the need to establish a whistleblower protection commission or authority as part of a second stage of reforms. What do you see as some of the priority issues for any discussion in relation to that? You flagged some of those in your opening statement, Mr. Droppett, but you might want to add to that so we can get a clear idea of what we should be looking forward to. I think you're on mute still. I'm sorry, sir. Thanks.
I'm not, without trying to duck it, can I say, given the very specific focus of Judge Wheatley's observations and his organisation's interests, I'm happy to let him go first.
Thank you.
Yes, thanks very much, Chair. Well, I suppose one of the interesting things that will need to come up in the discussion is where we place, in legislative terms, such an authority. And I think that the Whistleblower Protection Authority, from our point of view, would fit very nicely within the structure of the National Anti-Corruption Commission. And you know, the proof of that, I think, is that in the private members' bills that came forward over the years before Labor came to power and was then able to, make positive its commitment to have a national anti-corruption body. The private members' bills all sought in one way or other to incorporate the Whistleblower Independent Protection Authority within that structure of that legislation. And we think there's a lot of sense in that because of the propinquity of a Whistleblower Protection Authority to the work that is to be done by the National Anti-Corruption Body. But as I said, the important thing, I think, is to ensure that if the legislation is included within that confine, that the independence and independent integrity of the National Anti-Corruption Body be preserved. And I think that's one way it can be achieved, because there will be a close connection between commissioners, on the one hand, checking to see whether there's been any serious corrupt conduct, whether criminal or not, and on the other hand, agencies that are seeking to protect the whistleblowers who have come forward and who have provided the information that leads to the commencement of those investigations. So that seems to us to be a very neat way of tidying up the legislation and also preserving independence, while at the same time recognising the close connection between whistleblowers and the investigation of corrupt practices.
Can I add to that by saying, in principle, the Australian Lawyers Alliance finds that also to be a suitable mechanism, but with one caveat, and that's to ensure that it's not confined to the subject matter of the NACC types of investigations, and would have also include non or private sector whistleblowing as well.
Yeah, I know. I think you're on mute, Chair.
I think you're muted.
Just handing the call to you, Senator Scarr.
Thank you very much. I want to touch on a few subjects which we haven't touched upon this morning. So I'll go to you first, Mr. Schimmel. And I was very interested in the comments you made around waiver of confidentiality of disclosure identity. And I think you made some very good points, or Maurice Blackburn made some very good points in that regard. And from my reading of your submission, it comes down to the fact that unless the provision is very carefully drafted, there can be an unintentional disclosure of the identity of the disclosure, and great care needs to be taken, especially given the vulnerable position that many whistleblowers are in, that any disclosure of identity or any intention in that regard should be clear and there needs to be some consideration of relevant factors in terms of assessing whether or not the whistleblower, the discloser, actually intended to disclose their identity. I'm wondering if you could just expand upon that point, please.
Yeah, well, thanks for the question, Senator. So, as a general concept, we support the proposed amendment. I think it came out of the Moss Review, recommendation 19 of the Moss Review, but there is just that issue, I think, where things could be tightened up and improved a little bit in terms of what's being proposed. Just given that it, in some circumstances might not be entirely clear whether there was that, or the extent to which there was that subjective intention for someone to disclose their own identity. I think probably the easiest way to deal with that issue would be to insert some guidance, as we noted in our submission, to insert some guidance into the bill, which sets out some of the factors that might be considered in terms of whether and the extent to which someone intended for their identity to be revealed. So that's probably the easiest way, we think, that without interfering too much with the bill to address that issue.
Yep, I certainly found your proposal quite attractive in that regard, I must say. I want to move on to another subject, and that is the categories of report receivers. And one category which is not touched upon in terms of your submission is that of health professionals. And so I'm interested in your thoughts around the need for whistleblowers to have the ability, especially given their position of vulnerability, the stresses that they're under, bullying they may be subjected to as a result of taking action which is in the public interest, the ability of those whistleblowers to actually be candid and open with health professionals who are perhaps assisting them and providing support, health support, other support in the course of their journey. Do you think the categories of report receivers should perhaps be widened to include health professionals?
It's not an issue that I had thought about, or a specific issue that I thought about previously, but my first reaction to it is that it does seem to make sense. I can see, it's probably not, or it may not be a circumstance that every disclosure finds themselves in, but certainly is something to be available if need be. And one can think in particular of mental health professionals, but being an appropriate person to receive that information. So yeah, my first reaction is that it does seem to be some merit in that, and probably a fairly straightforward sort of amendment to the bill.
Mr. Droppett?
I was just going to agree with my friend and say that, of course, health professionals themselves have duties of confidentiality. So the risk that a protected disclosure to even a general practitioner might then find its way into further, general circulation, I think has a fairly low risk. But of course, there could then be the proviso that ongoing publication from the recipient, of course, isn't part of the permissible disclosure process. Right.
Okay, thank you. I now want to move on to this vexed question of personal work-related conduct. So, as I've described it to other witnesses appearing today, you've got this definition of disclosable conduct. You then have potential exclusion of personal work-related conduct, and then you have exemptions from the potential exclusion of personal work-related conduct that you need to work through, and it's quite a maze to try and navigate through. The first issue I want to raise is there seems to be, in the explanatory memorandum and elsewhere, this distinction between systemic conduct and non-systemic conduct. So if conduct is systemic, then perhaps it falls more within the bailiwick of significant conduct or significant events, which would trigger one of the exemptions from the exclusion. But the question I have is, uncovering systemic conduct always begins with someone first disclosing a single incident, and it's that initial disclosure of a single incident which then perhaps triggers the identification that there's more to this than just a single incident. There's actually a systemic problem, and it hasn't just been encountered by one person within an organisation, but it's been encountered by many people, and appropriate action hasn't been taken. So I'm interested in the witnesses' views with respect to that. So if I could begin with you, Mr. Schimel-Paps, and then just go around the panel.
Yeah, well, I guess the difficult part of addressing this issue is how you frame it. As you say, there's a definition with an exemption, and there's an exemption to the exemption. There's probably different ways of doing it, and I think the trick would be to sort of settle upon the most rational and accessible way of addressing the issue, but noting, as you've said that, or as you've alluded to, that the single issue shouldn't be necessarily treated or regarded only as a single episode or a single issue, where it does potentially have broader ramifications for the organisation. I guess the difficult aspect to it is how you define that sort of broader ramification, whether you regard it as or define it as being systemic or significant or whatever else it might be. So I think that's the difficulty in relation to this issue.
Okay, Mr. Droppett.
We would say another way in which this issue could be addressed is if there's a general override in relation to serious and illegal conduct, and that then wouldn't require it to be systemic and could be captured, or a single event could be the start of the capture.
Okay, understood. Dr. Williams?
Thank you. It is not an issue that we specifically considered as part of our submission, but on the point that you raised, we would agree with our colleagues that you would want it to be broader than systemic, because a sufficiently serious single instance should also itself be enough.
Okay. I'll now move to my final question, because I'm keen to give my colleague Senator Shoebridge an opportunity, and that is in the submissions from the Australian Lawyers Alliance. And I just want to read this paragraph 14, because it certainly captured my attention. Quote, "Whistleblowers and their legal representatives should never have to contend with the possibility of being prosecuted and imprisoned or face any other negative consequences for seeking or providing legal advice relating to whistleblower public interest disclosures," end quote. Mr. Droppett, I'm wondering if you can, I just want to give you an opportunity to expand on those comments, because it seems to me if we are going to have a whistleblower system that is effective, that is providing support to whistleblowers who in many cases at great personal cost are performing a public good, then we need to make sure that those whistleblowers can obtain legal advice to assist them, to guide them through navigating what is a very, very complicated process. Is that correct?
Indeed, and without wishing to draw any direct parallel, there of course has been a very high profile case in the last, I think it lasted 5 or 6 years in the end, of a lawyer who got caught up in a sense, the whole process of whistleblowing and then the provision of advice. So no one should have to face that consequence, and there needs to be the express right to obtain advice, and then of course the protection that goes with that to the lawyer. And we support the proposed amendment to subsection 4 of section 20 of the PIT Act.
And Mr. Whealy, I'm interested in your views in that regard as well, and you made some comments with respect to the potential utility of a whistleblower protection agency and the need to make sure that potential whistleblowers are given all the support that they need in order to navigate what is somewhat of a legislative maze and It seems to me you refer to guidance, support, but there's also ensuring that those potential whistleblowers are given protection along their journey to make sure that in many cases where there's a great discrepancy or disparity, if you like, between the power of the individual whistleblower and the organisation, which is the subject of their whistleblowing, that they're given the support they need and the protection they need on that journey.
Yes, Senator, you couldn't put it any better than that. We agree with what you've said entirely. And I mean, the Bernard Collaery case was a classic example of where that protection was needed. Possibly Mr. Collaery didn't need much guidance, but he certainly needed a lot of support, and he needed protection, and that's what was missing. So I think you're absolutely right. And if I can also just go back to your previous question, I thought that I did have the privilege of listening in earlier when you were discussing this matter with Kieran Pender and AJ Brown. And, I thought the example you gave of bullying, one instance of bullying, of course, could reveal some very serious systemic problems within an organisation. So on both those points, I agree with you entirely.
Okay, thank you very much. Thank you, Chair.
Thank you. Thanks, Senator Shoebridge. You have the call.
Oh, cheers, Chair. Thank you again for all the work you've been doing, not only in the submissions you put in, but in the years preceding this in supporting whistleblowers. Could I ask you, is perhaps the first thing we should ensure with this bill is that it does no harm? It doesn't actually make it harder for whistleblowers to seek the protection of the Public Interest Disclosure Act. Should that be one of the sort of the starting principles we apply to the bill? I might go to you, Mr. Schimmel.
I think it's a reasonable ambition. I think the difficulty is what that actually means in practice.
Well, I suppose one area where I have difficulty with this bill in practice is the very broad definition in 29 capital A of personal work-related conduct. And I know in your submission, you say, in our view, best practice whistleblower legislation should include a broad definition of reportable wrongdoing, and any narrowing of that definition should be approached with extreme caution. Do you think 29A has been drafted with that extreme caution in mind?
I just repeat what I said earlier about striking that balance in that sort of difficult situation where there is that crossover. And as I said, there's probably a variety of different ways that you can address that. I suppose I'm not sure if I'd agree entirely with the way that you've characterised that, but I'll just repeat what I said earlier.
Well, it doesn't seem on my reading of it to implement recommendation 5 of the Moss Review, which said that the definition of disclosable conduct in the PID Act be amended to exclude conduct solely related to personal employment-related grievances. It doesn't adopt that solely test, does it?
Yeah, no, it doesn't. It does not do that. I agree with that.
And the Moss Review looked at the mess that public interest disclosure law was, and if you read the review, it makes it clear that word solely is actually important to ensure that the carve-out doesn't cause harm. That's right, isn't it?
Yeah, that's right. It doesn't in terms adopt the recommendation from the Moss Review, and that gives rise to that issue that we've all been discussing today, which is, how do you address that? And there's a number of different ways that you can do it.
Well, it doesn't in terms and it doesn't in substance address that recommendation, does it?
I'd agree with that.
Yeah. So I suppose I'll open it up to the panel. I might just, because it's easier if I pick someone, go to you first of all, Dr. Williams. Do you think inserting the words solely or only would be a good initial remediation for 29A?
We would agree with that. If that would give effect to the Moss Review recommendation, then we would agree with that.
Yeah, and I suppose each of you probably have spoken to whistleblowers and followed at least some of the journey they have through an organisation, and it often starts with whistleblowing and then has layered on it managerial responses, disciplinary action, and they become incredibly intertwined. That's not an uncommon experience, is it, Dr. Williams?
No, that's right. That's consistent with our understanding.
Yeah. Mr. Droppett, did you have any views on this?
In general terms, we would agree with you, Senator, that the insertion of the word only or solely would strengthen the overall objectives and, of course, is consistent with the Moss review.
You see the government, or the department, and no doubt the attorney will say, well, it's okay because if there's reprisal action as defined in sections 13 and 19 of the PID Act, that the exclusion won't apply. But do you have a view about whether or not those reprisal provisions in section 13 and 19 actually work in practice and would provide comfort for a whistleblower, Mr. Droppett?
Well, the answer is they might work in practice if a person gets to that point. I think the major advantage from the insertion of the word only or solely is that it takes away a degree of uncertainty for somebody who's about to embark on the first step. If they know that their complaint is not just solely about their personal situation but involves other issues, then they know that the protections that follow will be there for them.
Yeah. Well, you see, one of the problems that's been pointed out in other submissions of those reprisal provisions in the current Act is that there's no reverse onus. That if you want to get the protection of the reprisal provisions for the purposes of the 29A carve-out on your whistleblower, or the prosecution seeks to prove reprisal, you have to get into the mind of the manager or the person taking the reprisal action. You have to prove that they intended it or were reckless about it. And that's an extremely hard task for a lawyer, isn't it?
It's impossible, really, Senator. It's impossible. And time after time, you've seen prosecution cases brought that have failed just because of that difficulty. And often in situations where you would have thought that the position was clear. But so it doesn't work in practice. That's the simple thing. And I mean, we take the view that, as Dr. Williams said, that if the Moss Review have made this recommendation, well, then it ought to be there. And at least it will provide a clearer picture for progressing protection.
Yeah, so I think, Ms. Wheeler, I can take from that no whistleblower will take comfort from the idea that if they can prove that it's a reprisal action, they're still covered by the whistleblower provisions. No whistleblower, if they spoke to a lawyer, would take comfort from that, would they?
They wouldn't take any comfort from it at all, Senator.
And of course, part of the concerns for a whistleblower is you can't understand the risk you're facing by speaking out simply by reading the PID Act, can you? You have to then go and understand 5 or 6 other pieces of Commonwealth secrecy legislation and work your way through a legal minefield. That task's pretty tough, isn't it, Mr. Wheely?
Oh, yes. I think somebody said it was a maze. Well, you know, it's a maze that has no beginning and no end. As far as I can see, you'd be just lost in the middle somewhere. So all points again to the need for an independent whistleblower protection authority that can at least provide a pathway for somebody who wants to blow the whistle.
Yeah, well, one of the recommendations by the Human Rights Law Centre, Transparency International and the Centre for Governance and Public Policy was that the Parliament should step up here and create a select committee whose job is to simplify and to improve the law across the board, both in relation to secrecy provisions and whistleblower laws. Do you think that's a task?
Yeah. Look, it's a very difficult task, but it's one that I think that has to be undertaken. It's happening in other countries, and I think, as somebody said much earlier today, Australia's lagging behind in this, and it's only by addressing all of those issues and pulling it all together rather than just making piecemeal reforms, that we will get proper protection for whistleblowers and a really first-class, state-of-the-art whistleblower protection situation in Australia.
One of the points raised in, I think, Maurice Blackburn's submission is the absence of there being a provision for exemplary damages, for some kind of serious financial repercussions for an agency that breaches the law in this regard. And one of the other options that's often spoken about is adopting a US-style qui tam jurisdiction, where if a whistleblower identifies public misconduct and has a financial cost to the public, that they get a proportion of the savings. Have any of you looked at the qui tam as an alternate option? And I might go to you first of all, to Maurice Blackburn.
To be honest with you, I hadn't thought about that. Whether that's appropriate in this sort of a situation, I'm not sure. Happy to consider that further and provide a written response if that would be helpful. There's probably quite a few complexities that are wrapped up in that issue. It may be that, you know, what we've proposed is a more straightforward and simple way of creating that sort of, you know, and the purpose of exemplary damages here really, we'd say, is to act as a deterrent. We think that the availability of exemplary damages would achieve that aim. Whether you need to address that issue by means of qui tam type proceeding, I'm not so sure.
Has anybody else looked at qui tam in terms of providing some recompense for whistleblowers? I mean, it's one of the principal measures used in one of the biggest comparable jurisdictions in the United States. Have any of the other witnesses looked at it?
We haven't analysed it, but I have looked at the work that's been done by Kieran Pender in that area, and I certainly think that prima facie there's an argument there for introducing it in Australia.
Dr. Williams?
Thank you, Senator. I was going to say that I would agree wholeheartedly with Mr. Whealy on that point, because we'd be wanting, and also to consider the exemplary damages point, because what we'd like to see is a system that strongly deters breach and also really incentivises reporting. And so that's where, of course, this kind of scheme comes in. I would be happy to come back to you with more information on notice if that would be helpful.
I would appreciate that, because at the moment, all the incentives in the system on the part of a whistleblower are to do nothing, because you know the impact it's going to have on you personally, you know the impact it's going to have on you professionally. And so putting in place an exemplary damages provision or a qui tam kind of provision would at least provide some incentives for public interest whistleblowing to counteract all the negatives. Do you agree, Dr. Williams?
I agree entirely, and it's really important that those mechanisms are put in place, because we rely on whistleblowers. They play a vitally important a role in achieving accountability within our system of government, and therefore we should be doing all we can to incentivise them to report where there's a report to be made.
Go ahead.
Can I just say, from ALA's point of view, exemplary damages are a fairly well-known aspect of Australia's legal system. Often the awards made for exemplary damages are not large and don't really operate as a punitive influence on the recipient of exemplary damages awards. But I think we would be more inclined to go that route rather than incentivising a whistleblower with a known financial, with the prospect of a share of the savings, so to speak. But if it proved over time that insertion of an exemplary damages clause wasn't operating in the way that it was intended, perhaps we might need to look at American-style elements to change the landscape further.
Well, I mean, the qui tam provisions at least have the benefit of aligning self-interest and public interest and have saved US taxpayers countless billions of dollars. They at least have that benefit, don't they? It'd be one area where self-interest and public interest was actually aligned in whistleblowing, which is not a bad thing.
No, and I think the other point too, you know, is that courts don't really like awarding exemplary damages. And when they do, they make a lot of fuss generally about how this is to act as a deterrent, and then they impose a bundle of damages that's pretty light on. I don't know why it is, but it's inevitable. If you look at all of the cases where exemplary damages have been awarded, it's almost inevitably the case that they're light on. So I think the qui tam offers a better incentive to whistleblowers, even though it's not something we're used to in Australia. You know, we still tend to regard whistleblowers as dobbers, you know, people who we don't really like that much, you know, and they're not liked at work that much. So we've got the wrong attitude to whistleblowers right from the start, and it makes their life a misery. And when they come forward and they actually have the courage to report something serious, they're treated dreadfully, really. I think giving them an incentive like this that does coincide with the public interest has got a lot to recommend it.
Senator
Can I just jump in to say, given that, sorry, you go, Catherine.
Oh, thank you. Look, I was just going to say also in respect of the exemplary damages point and its ability to function as a deterrent, I would suppose we just need to think carefully about whether that will deter agencies that will be, that the penalty will be using taxpayer funds, not their own personal funds. So obviously if you're talking about an individual who themselves would have the consequence of having to pay those damages, that might really deter them from wrongdoing. But where we're talking about taxpayers' money being used to pay these exemplary damages, I'm not sure about the real potential to function as a strong deterrent.
You can almost hear the manager say, well, you know, bite me, it's not my money.
Exactly.
Sorry, Mr. Droppett.
I was just going to say, although I had jumped in favour of exemplary damages, having listened to Judge Whealy, can I say that the committee should give great weight to his observations? It was a very powerful point he made.
Indeed. Look, the last point, because our time is running short, in terms of seeking legal advice to be a whistleblower where one of a raft of federal secrecy provisions may be at issue, do you see merit in the Commonwealth urgently publishing a list of lawyers who have security clearance so that if somebody's seeking to get some legal advice on the secrecy provisions and whistleblowing, there's at least a door they can knock on and they can identify a lawyer? I suppose, is there a concern about there being a limited list, or is that just an unambiguously positive thing?
For my part, the answer is yes.
It's an unambiguously positive thing?
The initial question, yes to the initial question, should the Commonwealth make a list available, and doing that, would that be a positive thing? Yes.
Yeah. Any other observations on that? It seems to be low-hanging fruit. Like this could be done, you know, without even legislative reform. It could just be done tomorrow. Dr. Williams?
Look, I agree again wholeheartedly, because we should be doing whatever we can to make the system as easy to navigate as possible, and that seems a very common sense measure indeed to me.
Yeah. Look, again, thank you all for your submissions. There's actually a bunch more questions, but we have just run out of time.
Thank you very much, Senators, and thank you to all of the witnesses for joining us today and providing evidence. The committee will suspend for a short break and will return at 12:15. Thank you very much. Thank you. I now welcome the Office of the Commonwealth Ombudsman and the Australian Public Service Commissioner. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I just want to remind senators that witnesses and the Senate that the Senate has resolved that an officer of the Department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy. It shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask each of our witnesses who are here with us today, can you please state your full name and the capacity in which you appear?
Katrina Dwyer, Director of the Public Interest Disclosure Team, Office of the Commonwealth Ombudsman.
Ian Anderson, Commonwealth Ombudsman.
Helen Wilson, Deputy Commissioner at the Australian Public Service Commission.
Claire McLean, Acting Assistant Commissioner, Integrity, Performance and Employment Policy, Australian Public Service Commission.
Thank you very much for all joining us today. Do any of you have an opening statement that you'd like to make before we go to questions?
Yes, Chair, I do.
I don't, so I'm happy to leave it to the Commission.
Thank you, Commissioner.
Thank you, Chair and members. The Australian Public Service Commission welcomes the proposed amendments to the Public Interest Disclosure Act 2013. Under the Public Service Act 1999, the Australian Public Service Commissioner's role includes custodianship of policy guidance on the APS Code of Conduct and functional responsibility to undertake inquiries into public interest disclosures relating to alleged breaches of the code in certain circumstances. In this context, the Commission believes it is appropriate that the bill seeks to exclude from the category of disclosable conduct matters relating to workplace grievances or behaviours that would be handled more effectively through other mechanisms, such as a code investigation or a review of action. We envisage that the proposed amendments would result in more efficient and expeditious handling of such matters. It would enable agency resources to be used more effectively to the benefit of both general complainants and whistleblowers for whom the PID scheme is intended. The Commission is of the view that individuals making complaints that fall outside the scope of disclosable conduct will continue to be protected from reprisals, ultimately through the Code of Conduct, as behaviour amounting to reprisal action would constitute a prima facie breach of the Code. The Commission's handling misconduct guidance provides advice to agencies on measures they can take to protect complainants. The Commission also welcomes the proposed requirement that principal officers provide education and training on the PID scheme and on integrity and accountability more broadly. This would provide needed clarity on the scope and operation of the scheme, including the role it plays in the broader Commonwealth integrity landscape. We note that since February 2022, integrity training for new starters in the Australian Public Service has been mandatory through the APS Commissioner's directions, and we would be interested in exploring linkages between our foundational integrity e-learning module delivered through the APS Academy and the proposed PID education requirements for principal officers. We are aware that subsequent tranches of amendments to the PID legislation are intended to include prescribing the APS Commissioner as an investigative agency for the purposes of the PID scheme. Provisions are already in place in the Public Service Regulations 1999 to give this intention practical effect, as the Commissioner is empowered to inquire into public interest disclosures. To the extent that they relate to alleged breaches of the Code of Conduct where the Commissioner agrees it would not be appropriate for the disclosure to be made to an agency head, or where a disclosure has been considered by an agency head and the Commissioner agrees the outcome of that consideration is not satisfactory. Currently, the Commissioner can investigate public interest disclosures of alleged breaches of the APS Code of Conduct by agency heads. Our discussions with the Attorney-General's Department to date have reflected the context of the Commissioner's current integrity functions under the Public Service Act and how the next phase of proposed whistleblower reforms may integrate the Commissioner's existing functions and the government's other proposed integrity reforms. We are pleased with the outcome of these discussions and do look forward to continuing to work with the Attorney-General's Department on amendments to the PID Act. Thank you.
Thank you very much. Senator Scarr, do you have questions?
Yes, I do. So I might start my questions to Mr Anderson, if I could. So you didn't have an opening statement, Mr
No, happy
Anderson?
to go straight to questions, Senator.
Okay. I'd like to take you to paragraphs 12 and to 16 of your submission with respect to what you refer to as a carve-out of personal work-related conduct, and that has been the subject of some discussion during the course of this morning with different witnesses. And in essence, we have a situation where you've got a definition of disclosable conduct, you then have an exclusion of so-called personal work-related conduct, and then you have some exemptions to the exclusion with respect to conduct of a particular level of significance. And I just wanted to...
It's all very simple and easily navigable.
And I just wanted to take you in the first instance to, and perhaps to underline what my colleague Shinda Shoebridge is intimating, hopefully Hansard can pick up irony. The difference between your characterisation in paragraph 13 and the words in the proposed section. So in your introductory paragraph, you refer to, unless the personal work-related conduct relates to systemic wrongdoing or constitutes reprisal action in relation or disclosure under the PID Act. So you refer to systemic wrongdoing or reprisal action. When we actually look at the drafting in the provision, there's actually no reference to systemic at all. There's a reference to, quote, is of such a significant nature that it would undermine public confidence in an agency or agencies, or has other significant implications for an agency or agencies, end quote. So is that, Mr Anderson, is that an example, I guess, of the subjective nature of the amendments that you've identified in terms of your submission, that it's hard to sit here and read the exemption to the exclusion and truly understand what is that intended to capture? It may well, and I would assume it includes systemic wrongdoing, but it may include other things as well. It's hard to sit here reading those words and understand the full breadth of them. So I'm interested in your views with respect to that point first.
Look, I absolutely agree, Senator. It's a complex act in the first place, and the amendments that are proposed in the bill don't change the fact that it's still a challenge for proposed disclosures and for disclosures and for agencies to step through the different tests for the different stages of the process. But so when we say systemic wrongdoing, we're talking about a reference in the bill to conduct being of such significant nature that it would undermine public confidence in an agency or agencies, or has other significant implications for an agency. Now, in our experience, not just with PID, our experience generally is anything that requires a discretionary interpretation and decision is more likely to be open to differing interpretations. And so we think that generally the way in which personal work-related conduct is dealt with is more likely to generate a lot more complaints, because disclosures will say, clearly my disclosure is of such a nature that it should proceed and be treated as a PID, whereas a principal officer or authorised officer might be saying, we don't think it actually meets the test to be treated as a disclosure under these amendments. So we think that there is absolutely a significant risk that what we'll end up with is aggrieved disclosers who feel that their complaint should have been treated as a disclosure for the purposes of the Act, and they will then refer those complaints to my office.
And that difference in terms of perspective is a really important one, I think, because to some extent the authorised officer who's potentially dealing with numerous complaints, and I don't want to in any way besmirch how the authorised officers think in practice, but one can imagine an authorised officer receiving something, and as we've discussed earlier today, quite often there's an intertwining between the personal work-related conduct and the disclosable act, right? For example, the example I gave, someone raises legitimate concerns in good faith, they get accused of not being a team player, they get an adverse performance assessment. So you've got a personal work-related conduct, but you also have, well, what was the underlying issue that triggered that conduct, right? So the two are intertwined, and one can imagine an authorised officer receiving that initial complaint saying, oh, well, this is personal work-related complaint because he or she has raised bullying, and my concern is that significant hurdle, the significant nature, it's got to be significant nature that it would undermine public confidence in an agency. How does an authorised officer actually determine that in practice?
So if the bill is enacted by Parliament, then one thing that my office would be looking at doing is to provide guidance for agencies. But even then, guidance material will only take the matter so far in assisting authorised officers to understand the provisions. The first limb is also challenging in that it's either the significant nature or it constitutes taking a reprisal. Now, if you're a discloser, you're likely to be seeing reprisals in almost anything that's been done with respect to you. But then from a point of view of an authorised officer, that might again be just reasonable administrative action. So both limbs are open to that subjective question.
And with respect to that issue around reprisal, Senator Shoebridge has raised, I think, a very good point in terms of where the onus of proof lies in that respect. So certainly in my experience, more in the private sector than the public sector, is if someone's being performance managed or has missed out on a promotion or some sort of opportunity, then really the onus is on the organisation, which has the Human Resources Department, which has the senior management who are involved in the process, to document why that is the case, as opposed to the person who potentially is in a very vulnerable position who's blown the whistle, having to justify why it was reprisal, not a legitimate administrative action. I'm interested in your views in that respect.
I agree, Senator, that it is, in the first instance, for the agency itself to say, well, what records do we have that go to the decisions that are complained about? Was it something that, for example, was in train prior to any question of the disclosure being made, or was it something that was commenced at a later date? So the timing will always be significant. And then does the documentation actually point to a properly conducted process? So ideally, for employment-related matters, they shouldn't be coming as a surprise to an employee, that there should be a pattern of discussions with supervisors, for example, before you end up with a performance management situation. So there should be, the agency should be able to display that, yes, there was a proper process, well documented, not going to be a surprise to the discloser. And if they don't have that documentation, then it certainly lends a lot of credence to the allegation that actually this is a reprisal action rather than a proper administrative action.
Yeah, and I agree. And someone who is within an organisation, they're acting in bad faith, they can actually also potentially generate a document trail that potentially supports their position that, oh no, this is just run-of-the-mill performance management. It has nothing to do with the disclosure, especially given that a person within an organisation might be looking ahead because someone's raised some concerns internally, and that person is then characterised as a troublemaker and someone we have to performance manage out. Isn't that correct?
Absolutely, and the bill does deal with a situation where a potential reprisal could occur in advance, well in advance of a disclosure being made for exactly that situation. Yep. But I think if you step outside the PID context, it's good administrative practice for agencies to document their employment processes and practices. And I think the Commission would agree that whether it's a PID or just generally dealing with your staff, you should be actually having clear processes that are well documented so that no one's caught by surprise. Whether it's been then perceived as a reprisal or then perceived as just poor management practice.
Commissioner?
Absolutely agree that each agency needs to have the appropriate guidance in place for all these sorts of circumstances.
So really, if an organisation, an agency is conducting itself the way we would reasonably expect it to conduct itself, with people in key roles relating to human resource management, executive management, they should be able to demonstrate that performance management or administrative decisions that they've undertaken have been undertaken in good faith, and they shouldn't have any issue in terms of demonstrating that if the onus were put upon them to demonstrate that on the balance of probabilities. Is that a fair comment?
Well, it is now in the context of the Comcare scheme where people make workers' compensation claims in relation to particular performance management actions that may have affected them, aggravating or causing an illness or injury. Agencies would need to be able to properly document that if they're making an argument that decisions were made in relation to reasonable administrative action.
Excellent. My next area of questions before I share the call, Ms Dwyer, I'm very interested to understand what the Commonwealth Ombudsman does now in terms of a potential whistleblower. So we've discussed earlier today about the potential, well, the real legislative maze that a potential whistleblower is confronted with. The stress associated with having potentially tried to raise concerns internally in an organisation, not getting any traction, potentially getting really severe pushback, and then in that context, and I can only try and put myself in the shoes of a potential whistleblower, the tension between do I really want to be the one to put up my hand and bring these issues to account, or should I sit back knowing that if I do put up my hand, I'm going to be going on a journey potentially, which may have consequences both for me personally and my family. So I'm interested in terms of if I'm that potential whistleblower and I reach out to the Ombudsman Commission, what support, what guidance, what protection can the Ombudsman Commission provide me today, as the law is today, and in terms of your powers today?
So I might start with that, Senator, sure. And I'll defer to my colleague if I need to. But look,
I did my best, Mr. Wyatt.
Senator, the first thing we can do is we can provide information. So we do get contacts directly from people who are proposing to make a disclosure, and they ask us questions about what the process is. We also publish material, so there's an education part of it. The support and protect part is very challenging though, and it's a common complaint from disclosures that they don't get any support, they don't get any protection. There's the formal protections that you get in terms of protection against reprisal, but our experience from our limited visibility of the matters that are being handled by agencies is that while reprisal allegations are made, they're not substantiated when they're looked at by agencies. So it does seem that in practice, disclosures are not able to prove that to the satisfaction of an authorised officer that there was in fact a reprisal, yet it's a very clear and common belief that there are reprisals happening. I should say we did an own motion investigation last calendar year and that looked specifically at 4 agencies who've had a lot of PID experience, and we looked at how they deal with the question of reprisal. How do they do reprisal risk assessments, things like that. And we did find that even if agencies are good at doing the assessments, they're not always as good at actually putting the assessments into practice. So they might identify risk mitigation factors, but they're not necessarily that good at making those real live factors that are in play to mitigate any reprisal risk during an investigation. So it is a real challenge, and we're hamstrung both by our lack of visibility in that we don't necessarily see very much about the average PID, and also then by just a question of resourcing in terms of our ability to actually help people if they do reach out to us. Now, disclosures can complain to us at the end of a matter if they have complaints about the handling of a PID, and we certainly look into those matters, but it might be too late in one sense if the disclosure already feels that reprisals have occurred.
And that's complaining after the event is not the same as having someone with you or an agency, the support of an agency with you every step of the way as you go through the process, providing the guidance, the support and the real-time protection, is it?
Yeah, we don't have that real-time role currently, and obviously that's a question that the government has said that they will consider in the second phase, which is should there be an authority, commission or someone given that role of actively supporting and protecting whistleblowers. And we've said in our submission that that's a role that we could take on if government wanted us to, but then there would need to be a question of resourcing as well.
Ms Dwyer, is there anything you want to add?
Thank you. Yes, I'll just follow on from the Ombudsman's comments there in relation to the own motion investigation that we did, and particularly in relation to the some of the insights that we found in relation to reprisal risk assessments, and the need for agencies to do sort of regular reviews of those assessments. So sort of not just do it up front and then leave it, but regularly be checking back in on that assessment. And importantly, at the first stage of the engagement with the discloser about what they perceive the risks might be to them, and that being a critical part of the process in doing that risk reprisal assessment.
I mean, to some extent, this is my last question. It's when you were talking there, Ms Dwyer, and you're talking about the Commission, the Commonwealth Ombudsman talking to the discloser about the risks to them. Ideally, best practice is potentially an agency, whichever agency it is, actually advising the discloser what the risks are to them based on the agency's past practice and actually helping the potential discloser to navigate through those risks. Because if you're doing it for the first time and you haven't done it ever before, you're really looking for guidance with respect to what may happen on the journey. Isn't that correct?
Yeah, my apologies. To clarify, I was talking about agencies needing to engage with disclosures about what they perceive the risks to be, so that they have a voice in that process.
Yeah, understood. Okay, thank you, Chair.
Thank you very much, Senator Scarr. Senator Shoebridge.
Oh, thanks, Chair, and thanks to both agencies for your submissions. Is it the Ombudsman's experience that once somebody in a public agency is a whistleblower and identifies themselves as a whistleblower, that quite often they face a difficult pathway through the organisation? They can feel excluded, they can feel marginalised, and they quite often have a very difficult pathway through the agency.
So, Senator, it is our experience that once someone takes the option pursues that option of whistleblowing, that yes, their pathway does become more difficult. That's not necessarily based on a lot of evidence, but that is based partly on our assessments of PIDs and what we see. There's a couple of factors at play there, of course. It's a pretty difficult thing for someone to actually gird themselves up and get themselves to that level of, okay, I've tried internal disclosures, I'm going to now potentially do an external disclosure, and they're certainly not making themselves popular within the agency. That said, it doesn't have to be that way. No. But I will say, if I could just round that out, we've also observed that there are scenarios where once you've got yourself to the point of saying, this is what I need to do, levels of trust are generally very damaged, if not irreparably damaged. And so the whistleblower is likely to interpret any action that the agency does there through that lens of, it's because I'm a whistleblower, and that's not necessarily the case either.
Oh yeah, I'm not suggesting every instance where a whistleblower believes that the actions taken against them relate to the whistleblowing is proven or provable in substance. But that relationship which I think you've articulated well, the breakdown in trust, and it can be a very fractious relationship between the whistleblower and the agency once the whistleblowing is done. That's a not uncommon pattern.
Absolutely. And the agency can seek to repair that depending upon what the outcomes are with the disclosure. I mean, Philip Moss, when he did his review, he said that secretaries came forward and said, look, there were some significant substantial benefits that could come from whistleblowing. And so if you had a scenario where something actually significant happened, people were moved out of roles, agency behaviour changed significantly, then that will hopefully help to start rebuild the confidence and trust of the whistleblower.
And Ms Wilson, would you agree with that sort of summary of the relationship between whistleblowers and agencies? It's not uncommon for it to become quite fractious.
I don't think I can comment on that, Senator. I think it's case by case, agency by agency. What I would note is that there is protection from reprisals available outside the PID scheme. Retaliation against someone who has made a complaint in good faith could be a potential breach of a number of elements of the code. So I would just make that broader point too, that the protection against reprisals is available outside the PID scheme.
Do you have any numbers or instances you can point to where the code's been used to protect whistleblowers in that way?
I don't to
We don't
hand,
have that
no.
level of visibility of the way agencies use the code either before or after a PID may or may not have been made.
So that's a theoretical protection that lies in the code. That's what you're putting before us.
Well, it's a prima facie breach of the code too.
But you can't point to any instances where the code's been used.
I can't, no.
Okay. The recommendation 5 of the Moss review is kind of one of the critical recommendations that the government says they're seeking to implement with this bill. But of course, recommendation 5 of the Moss review talks about how the definition of disclosable conduct in the PID Act be amended to exclude conduct solely related to personal employment-related grievances unless the authorised officer considers that it relates to systemic wrongdoing. Now, there are 2 parts about that recommendation that I might take you to, but I'll start with the first point, that it should exclude conduct solely related to personal employment grievances. Do you accept that 29A of the bill doesn't implement recommendation 5 because it doesn't use or seek to engage with that term solely? I might go to you, Mr Anderson. It's dissonant to recommendation 5, isn't it?
I'm just double checking the bill before I agree with you, Senator, but...
Page 5,
yes.
clause 29A.
Very prudent, Mr Anderson.
Clause 4 of the bill, I think, the proposed 29A. Doesn't use solely or only.
Solely is not language that's used, and I think that Philip Moss's recommendation was a very clear recommendation. His report talks about the particular challenge of having a very large volume of personal disclosures that seem to relate very much to personal work-related conduct. So that's not how it's been put into practice. That's really a matter for the Attorney General's Department later today.
Yeah, but the effect of it is, not using the word solely, is that it means that that carve-out is significantly broader than recommendation 5. That's the effect of it.
I'm not sure that I'd agree, Senator, that it's significantly broader, but I think that it's...
We can have an argument about significantly later, but
so
it's broader.
Semantics,
it's broader,
but
isn't it?
It certainly doesn't completely align with recommendation 5.
Yeah. Ms Wilson?
And I think it would be a useful thing if it did, but
Indeed.
we've pointed in our submission to challenges that...
We'll come back to some of... Your challenges relate to the second half of the Moss recommendation 5, and we'll come to that in a sec. But dealing with the first half, Ms Wilson, do you agree that the language in 29A does not align with recommendation 5 in the Moss Review?
That's a question best asked of Attorney General, Senator.
Well, you have given, your agency, the Public Service Commission, has given wholehearted support to this bill. And I assume in part of that, you looked at the Moss Review and you worked out whether or not it was implementing the Moss Review.
We did.
Did you do that basic due diligence when you were looking at writing that
Senator.
2-page letter?
I can assure you we do, and we still support the amendments, but I do think that's a question best answered by Attorney General.
But it's going to have a significant impact on the Public Service Commission whether or not the Moss Review is implemented. You didn't turn your mind to whether or not 29A actually implements recommendation 5, the key recommendation.
We did turn our mind to it, Senator. I'm going to pass to my colleague Claire.
I think we took the view at the time that this was an iterative process, that the consultations were in a limited period of time, and we provided our comments on the text of the bill in the timeframe that we were given. I don't think it's a question of due diligence in terms of
Well, it just doesn't.
comparing against the Moss Review's specific wording or not.
Well, we can have a semantic discussion, but it just doesn't implement recommendation 5, does it? Because recommendation 5 talks about solely personal work-related conduct, and clause 29A of the bill doesn't replicate that, does it? They're not the same.
I accept that's your view.
Well, I'm asking you though. You've looked at the Moss Review, you've looked at the bill. You said it was quick to get the submission in, but you've now had time to reflect on it. I'm asking you now.
You've now had time to listen to Senator Shoebridge's
And the other witnesses
analysis.
and all the other analysis we've got in this.
Just draw your attention to those opening remarks that I made about what public officials are and aren't able to answer. And I appreciate you've put the question in a few different ways, but there are certain things about opinions that they're not able to answer in this forum. Do you have any other questions?
I do, yes, thanks, Chair. The second part of recommendation 5 of the Moss Review was talking about a carve-out from the exclusion, to go back to that convoluted language, where the authorised officer considers that what might otherwise be a personal employment-related grievance relates to systemic wrongdoing. And I'm assuming that the wording in your submission from the Ombudsman sort of reflected back that systemic wrongdoing in recommendation 5 of the Moss Review, is that right?
Yes, but it also does reflect, Senator, I think that this, as I explained earlier, the way in which the bill is drafted in terms of conduct of such a significant nature that it would undermine public confidence in an agency or agencies plural or has other significant implications for an agency or agencies, we think that's a way of saying systemic wrongdoing.
That's 29.2.2a.
Yes.
Yep. And again, I might go, well, and the Ombudsman's concern is that that language is potentially extremely broad. And indeed, from the view of a whistleblower,
that's the
very, very often...
the disclosure, Senator.
Sorry?
That's the reason why they've made the disclosure,
Correct.
because they believe it's going to tick one of those boxes.
Yeah, so that if your concern is that if an authorised officer in an agency says, oh, doesn't satisfy the proposed new 29.2a, doesn't satisfy that, you're caught by the exclusion, that inevitably that complaint is going to come to your office because they're dissatisfied with that decision.
That's our perception, Senator, of what's going to happen, because it's a broad and subjective test.
Yeah. So I might go to the Public Service Commissioner. Again, you endorse this bill unambiguously, but it seems to me...
Your word, Senator.
Well,
I don't think we've ever said...
I can read from your letter.
We've endorsed certain measures in the bill that relate directly to the Public Service Commission's role in the integrity system.
It seems to me that proposed new clause 29.2a, particularly subsection B, is going to create enormous uncertainty within authorised officers. I mean, I can't tell.
I would disagree.
Let me finish though. I can't tell what an other significant implication is, let alone identify whether or not a matter is of such a significant nature that it would undermine public confidence. These seem to me hugely subjective tests that reasonable minds will repeatedly differ on.
Our view is that agencies would be able to take an agency position on what that means for that agency in terms of the nature of their functions and operations, and would take the initiative to educate their own public officials about what that means in the context of that agency. And that would give more certainty and clarity to the authorised officers and the principal officer in that agency.
How many different agencies are there in the Commonwealth?
I can't.
I should know that
The
off the
figure
top
off the top of my head.
Depends on how you're clarifying, sort of if you're just thinking of Australian Public Service, Commonwealth agencies or non-APS, but we will take that on notice and get it straight back to you. Someone will be listening back in the...
We can only speak on behalf of APS.
A lot. There's a lot of them. Don't you see a problem, Ms McLean, if each agency is going to take their own interpretation of clause 29(2)(a)? That seems to me, let me finish, that seems to me to create even more complexity. So agency 1 will have one interpretation, agency 2 will have another interpretation, all on a highly subjective test. That seems a recipe for organisational complexity, chaos, unhelpfulness.
Well, that agency position would be taken in the context of guidance provided to them by the Ombudsman.
And Senator, I do feel you're again asking for our opinion agency by agency, which, you know, these questions might be better directed to each agencies. I mean, again, I would make the broad point that a lot of the amendments, as we said in our submission, are going to provide much needed clarity for everyone right across the Australian Public Service who engage with the PIDS scheme.
Well, you say clarity, Ms Wilson. Give me an example of conduct that has other significant implications for an agency. You say clarity? Give us some clarity here. Give us an example.
We would be looking at, we were taking the view that there are types of misconduct that go to the PID scheme that are only really handled via an individual code of conduct investigation or process at the end of a PID investigation, which is an enormous amount of delay and inefficiency in the handling of an individual complaint. Carving those out from the operation of the PID scheme is something that we are very conscious needs to be done as a matter of...
But this is a carve-in. This isn't a carve-out. You see, this is a carve-in. Something that has such other significant implications for an agency. There's not a carve-out.
Okay.
It's a carve-in.
I appreciate that.
This proves, doesn't it, this exchange we're having, proves how complex this is. And particularly if,
I don't
on your
disagree
position,
that it's complex, Senator.
And particularly if different agencies are all going to have different approaches to clause 29(2)(a), this seems like a recipe for chaos.
Agencies already take their own approaches to the triaging of a PID that comes in terms of whether it's eligible or not. This gives some greater clarity about the eligibility of a PID in the first place.
I asked for clarity, an example, just one example
of
the carve-in,
that to you today,
and you can't give me one. So I'm having trouble with clarity here, because if the Public Service Commission can't give one example where this carve-in will actually work, then how on earth is it giving clarity?
I take that on board.
Well, I had misunderstood the role of the Public Service Commission to be trying to get some consistency in agency responses. So when you think this will be implemented agency by agency?
We don't have a lot of visibility of how the PID scheme is implemented because we only see what is referred to us in the context of the Commissioner's own powers.
But you said, when I asked you about the Code of Conduct, which is part of your business, you said you also don't have visibility over that.
Not to how they're implemented in each agency.
I recall that exchange, yes.
So I'm troubled. That exchange makes your answer sort of more troubling.
Guidance, which we do, on the Code of Conduct and the APS values, and how processes under the Code of Conduct may be best administered. We also provide an evaluative function on how Code of Conduct procedures comply with the Commissioner's, the Act and the Commissioner's directions. we don't have a policing role over the code of conduct in agencies, and we certainly don't have a policing role over the PID scheme.
In terms of the, for the Ombudsman's office, the level of information that's provided to your office about how the PID Act is currently operating from different agencies, are there some concerns about the level of systemic reporting that's coming to the Ombudsman's office, or is that working at the moment?
Senator, before I answer that, it probably would be useful just to, for the sake of Hansard and listeners to this process, just to note that the Ombudsman's office does produce agency guidance material, and we do have a PID handling guide, and we would look to produce additional guidance material about how to interpret this section.
And I read that in your submission, and I think that will actually provide at least some clarity if it goes through as currently drafted. But nevertheless, I'll come back to my earlier question.
So in terms of that question, Senator, we do get quite a limited amount of information. Agencies are required to, for example, provide us with notifications when they allocate a disclosure, when they decide not to investigate a disclosure or not to investigate a disclosure further. And then we get statistical reports about the number of disclosures, the kinds of disclosable conduct to which they relate, the number of investigations conducted, and actions taken by principal officers in relation to recommendations. So we get that sort of information, and that is quite limited, and it's certainly the case that individual agencies might choose, for example, in disclosing actions taken, they might simply say actions were taken, or they might describe in some detail actions that were taken. It's the same with the question of giving reasons not to allocate or reasons not to investigate. They might say there were reasons, and they might describe those in a very summary form, or they might actually set out what the specific reasons were in some detail.
Yeah. And
Senator Shoebridge, just to give you an indication, I have probably about 10 minutes of questions, so you've got probably another 5 minutes if that's okay with you.
I think I should get to. I'll finish before then, Chair.
Yeah, thanks.
And in terms of your oversight of the PID Act, that means at the moment you have a kind of statistical oversight, but you're not really getting a sense of the substantive responses from different agencies unless they volunteer the information to you.
Or unless we were to do an own motion investigation and go out there and seek information. So at the moment it's best described, I guess, as limited visibility.
All right. Is that going to be, well, I think in terms of your submission addresses some of the enhancing the oversight of the Attorney General's submission talks about it enhancing the oversight of the PID Act. And they say item 28 in part 2 of Schedule 1 will implement recommendation 3 of the Moss review. Have you looked at that as to whether or not it's going to address some of those concerns?
So I would just note, Senator, that Philip Moss talked at paragraph 41 of his review, and I'll quote, his review concludes that these agencies, talking about the Commonwealth Ombudsman and the Inspector General of Intelligence and Security, so the two agencies that currently have oversight of the PID Act, the review concludes that these agencies must be better resourced to assist agency heads to instil pro-disclosure cultures across the Commonwealth public sector. So the new powers that are proposed for us and the new information we'll have will be welcome. But the challenge for us will be that unless we actually receive some resourcing to carry out those functions, it'll be challenging for us to fully utilise the ability we'll have to get more information.
So it's a good thing you get the reporting.
It's a good thing we get the reporting. Question is, what will we choose to do with that reporting if we don't have any resourcing to actually look at the reports? And I should say, resourcing, senators are used to hearing agencies complaining about resourcing, and times are always tough. But there's a resourcing in terms of staff ability to actually look at things. There are some additional obligations we have to do 6 monthly reports that we don't currently do. And then we actually need to do some IT changes as well to be able to properly receive the reports and things like that and make sure we can track them all. So that's where the resourcing issue is.
And has there been any promises on resourcing to allow the Ombudsman to implement this? Have there been any commitments made that you're aware of?
So as you'd expect, Senator, we have engaged in discussions with the Attorney General's Department, but ultimately that's going to be a matter for government through the budgetary process. So that's not something we can say as to what's going to happen.
And these resourcing concerns may in fact be amplified if, as you fear, the bill gets implemented and then a whole series of aggrieved whistleblowers come to your office after different agencies have said their matters have been excluded from the PID Act because they're related to personal issues, employment issues.
Absolutely, that would be a growth in work for us.
It might be a pincer movement for you, an unhappy one.
Yeah, that's certainly the case, Senator, but all I can say is we've made representations to the Attorney General's Department of the matter for government.
Thanks very much.
Thank you, Senator Shoebridge. Is that all the questions you have?
It is, yeah.
Right, thank you. I just have some final questions. Thank you to both agencies for your submissions. They're really helpful. What I'd like to ask first and foremost, I just want to touch on something that was raised in the previous questions on guidance materials. So the Commonwealth Ombudsman, you said that you will be providing or redrafting guidance material for agencies. Can you just take us through what that guidance material relates to in relation to this Act, how that will assist agencies or employees looking at whether they need to, how their relationship with the referral process will be updated?
Certainly, Senator. We have, for example, currently an agency handling guide with respect to PIDs. It's I think around 79 pages or so that seeks to step agencies through the process, but that's also available to potential disclosures as well, because that's a published document. We also provide some other material about the PID process that we also publish, and then we do regular forums for agencies as well, at which we also seek to talk with PID handling officers in particular about how to I guess, step through the Act. And then we've done, occasionally we've done bespoke processes for individual agencies where appropriate to provide information for an agency that either wanted or seemed to need more information about the PID scheme. So it's particularly aimed at agencies in terms of understanding their obligations under the PID scheme, but that can also be of use to people who are considering making disclosures.
Okay, thank you. And from the Australian Public Service Commission point of view, do you currently provide guidance on these types of provisions, and you would have been thinking ahead if the bill is passed. What sort of training or guidance materials would you be looking to implement?
Well, we already have what we consider to be adequate and comprehensive guidance materials on the Code of Conduct, which is our remit. In particular, the Handling Misconduct Guide has some examples of mitigation strategies regarding identified risks of reprisals in the code process. So I would consider that in developing guidance on the changes to the PID Act. We'd be very happy to work with the Ombudsman to share some of those examples.
Thank you. Then I wanted to go to another issue you raised in the previous questions, Commissioner, and it's in regards to the personal employment related grievances. I know that there's been a lot of discussion today about the best way to deal with this type of situation that arises. And one of the things I think it was Deputy Commissioner pointed out was the impact on a matter being sort of almost drawn out if it goes through the PID. Am I right? I don't want to put words into your mouth, but the PID process would need to be played out before a code of conduct process. And I think in your submission, you're sort of talking about it being more efficient and effective for complainants and for agencies. Can you just, I guess, not someone who's had to go through that long process before, what are we talking about in timeframes? What would be the impact of on a person, with a code of conduct issue that they're looking at if it was dealt with through this process?
I might make an observation, having been an authorised officer in the past at other agencies. A PID that would predominantly relate to personal workplace grievances would go through the normal timeframes of the PID process, which can be up to 104 days. I think that was mentioned in the Ombudsman submission. It's certainly there's a 90-day time frame to provide a report to the disclosure. And if the ultimate findings of that report are that the misconduct should then be handled through a code of conduct process, that will then add additional delay for that process to then be carried out. So what we're thinking is that if these sorts of matters can be moved to the appropriate handling mechanism at a much earlier stage of the process, that would be more conducive to actually settling or addressing the issue at hand in the workplace, and could lead to greater trust and integrity in the workplace itself. That would obviously be better for the complainant and certainly better for the agency. And you would then be moving to a process that has much more clear mechanisms for procedural fairness as well for the persons against whom the allegations have been made.
Thank you very much. The other question I just wanted to ask was, I guess in a perfect world, we'd be dealing with all of these different mechanisms at the same time, or we would have, we're not dealing with this PID proposed legislation in a vacuum. We've got the Set the Standard report as well and the recommendations coming out of that. So I just thought I'd touch on the implementation of the Parliamentary Workplace Support Service. That's since been established, since the PID scheme has been established, and that provides an alternative avenue for current or former parliamentary staff to make complaints of misconduct in the workplace. Can you just explain the role of the service in dealing with complaints of misconduct, and is there an interaction with the Parliamentary Workplace Support Service since it's been established? It's only recently new, so I guess it's...
I'll try and answer the latter part of your question first, Chair. We do provide support to the Parliamentary Workplace Support Services from that corporate perspective, but we have no role and have very little interaction with the Parliamentary Workplace Support Service when it comes to the role that they're playing to allow current or former parliamentary staff to make a complaint of misconduct in the workplace. That those questions about the cases that they handle and how they go about their processes are much better directed towards the Parliamentary Workplace Support Service themselves, I think is...
Yes, and that, or potentially the task force that's been set up to implement the Set the Standard report.
Okay, thanks. Just one last question for the Ombudsman. One of the things that our committee report can recommend is obviously amendments to the bill, but also I note that sometimes the explanatory memorandum is needs a little bit of clarifying, and that actually helps people understand the purpose of provisions. Your submission notes that paragraph 2.73 of the explanatory memorandum mischaracterises the OCO's abilities upon receipt of an investigation report. Can you just explain why there's a mischaracterisation here, and what we can do to, what would be a recommendation around clarifying that mischaracterisation? Because I think it does have an impact on how the legislation will be applied later on.
Certainly. So, Senator, the recommendation 3, it's true, it does just say amend the Act to require a principal officer to provide the Commonwealth Ombudsman or the IGES with a copy of the investigation report within a reasonable period of time. And that's what is commented on 2.73. But it's the underlying intent of what actually comes from providing a copy of the report to the Ombudsman or the IGES. And Philip Moss talked in his report about that would enable the agencies with oversight of the PID scheme to then be able to better inform themselves, take a range of actions, seek more information from agencies, question whether they should have done something in a different way, for example. And that all depends upon actually being able to do something with the reports. So it comes back to the question I mentioned before about having the capacity in terms of resourcing to, in fact, be able to do something and to be able to do something in a timely fashion, because some reports, when you get a report saying we have decided not to investigate or not to allocate or the investigation has been concluded, that might mean that in fact the agency has now completed all of their action and some time might have passed before we in fact receive the report, and for us to then be able to step in and say you should do something now in the context of the investigation when it's already completed, it might be too late.
Okay, thank you. I appreciate that. That is all the questions that I have. If any other senator has questions. No? Well, thank you very much to the Commonwealth Ombudsman and to the Australian Public Service Commission. Thank you for providing evidence for us today. We just have one last witness before the committee for the day for officers representing the Attorney General's Department. And we'll give them an opportunity to come to the table. Thank you.
Large parts of the public service remind me of self-sealing fuel tanks. You know, when they self-seal. Self-sealing fuel tank.
Thank you very much. I think we're all ready to go. I now welcome officers representing the Attorney General's Department. Thank you very much for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy. It does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask if you could each please state your full name and the capacity in which you appear today?
Thanks, Chair. Celeste Moran, First Assistant Secretary, Integrity Frameworks Division, Attorney General's Department.
Parker Reeve, Acting Assistant Secretary, Transparency and Administrative Law Branch, Attorney General's Department.
And Kristen Crawford, Director, Administrative Law Section, Attorney General's Department.
Thanks. Would you like to make an opening statement before we go to questions?
No, Chair, we're happy to go straight to questions.
Great. Deputy Chair, Senator Scarr, I'll hand the call to you to kick us off.
Thank you, and thank you to all the witnesses for joining us today. This must be the most satisfying part of your job. But can I just commend everyone who's been involved in this process? It's one thing for us to sit here and ask questions about the drafting, etc., and ask the questions we need to ask in order to discharge our responsibilities. But I do recognise the obviously substantial work that's gone into this amendment bill. So,
and the usefulness and quality of the submission, actually engaging with the issues is really helpful.
Yeah,
thank you.
Excellent. So, first question won't come as any surprise in relation to the definition of employer work-related conduct, and just walking through it as I understand the legislative scheme. You have a definition of disclosable conduct. You then carve out or exclude from that a definition of employer work-related conduct, but then there's exemptions with respect to that employer work-related conduct, which could bring it back in within disclosable conduct. So one of the concerns that's been raised during the course of today is the Moss review referred to solely employer work-related conduct and in our reading of the bill, we're concerned that that qualifier solely is not there to qualify what employer work-related conduct means. So I'm interested in your response to our concern in that regard first.
Thanks, Deputy Chair. I'll start at a high level, and I'll get my colleagues to give you the kind of technical aspects of it as we go. We've been following along today and we've heard the issues raised. I think we're clear on what Mr Moss's recommendation said and the intention around the use of solely. We obviously work very closely with the Office of Parliamentary Counsel in the drafting of the bill and have had extensive discussions with them about achieving that policy outcome. What I would say is that our view is that while we don't use the word solely in the bill, that the way that the provisions are drafted, it does actually have that effect. What I'll do now is get either Mr Reeve or Ms Crawford just to run you through our understanding of how that actually works in practice.
So I guess if I may, Senator, I'll sort of walk you through some of the provisions in the PID bill. I appreciate it's challenging to navigate, I guess, as you sort of work through it.
Is there a better way of talking about the carve-out to the exclusions to the exemptions?
I'm not sure that's a question, Ms Crawford.
If you can help us with that too, Ms Crawford, that would be
We've
helpful.
been working on it as we've been drafting. So I guess the key thing is, I know this has sort of been conversation today in terms of Moss review uses the word grievance, we're using the word personal work-related conduct, and that is because the Public Interest Disclosure Act works in terms of instances of conduct. So the key thing I would point you to is in section 26, which is the meaning of public interest disclosure, and when it talks about then what is an internal disclosure, so we start the chain. That's information that tends to show, or the disclosure believes on reasonable grounds that the information tends to show one or more instances of disclosable conduct. So then when we go to the definition of disclosable conduct, which is in section 29, where we now are putting in this new 29(2)(a), which is then saying disclosable conduct is not personal work-related conduct. It means it's only to the extent, only personal work-related conduct is excluded, but if there are other instances of disclosable conduct, that is still part of the disclosure. And that's part of the distinction, I guess, or the unique's not the right word, how the drafting of the PID Act works, which is different to the Corporations Act, which talks about disclosure of information and doesn't use a concept of conduct at all. So it has a to the extent that, whereas this is working as it's one or more instances of conduct, so it works always on the basis of being contained to conduct.
So, Ms Crawford, you've been following the evidence and the testimony, and you've had the benefits of reviewing the submissions. Given this testimony in those submissions, is the department, Ms Moran, going to reflect on whether or not there might be an opportunity to perhaps put the matter beyond doubt, so that it's perhaps that meaning, as Ms Crawford has walked through, and I understand the nuances, but is there potentially a way that the Attorney General Department could reflect on perhaps making that more accessible?
Yeah, Deputy Chair.
In terms of the drafting?
I think it's fair to say we've spent prior to today, but today as well, reflecting on the issue. One option is to include an explanatory note in the bill to make that abundantly clear, and so that's something we're thinking about.
Well, another option would be to actually,
amend.
for the avoidance of any doubt, A, B, C, D in a subclause, because clearly you have stakeholders, esteemed stakeholders who are experts in this area have raised this concern. Members of this committee have raised the issue as a matter of concern, and I would have thought that with some enhancement of the drafting, it could, notwithstanding, I respect Ms Crawford's analysis, that it perhaps could be put beyond any doubt and made more accessible, I think, to readers of the legislation. Do you think that's a fair comment to reflect on, Ms Moran?
I think we can take that on board, Deputy Chair.
So, Chair, Ms Crawford, could you take me through again how Section 26 impacts on Section 29 in such a way that I read Section 29A differently to how it's expressed in black and white? And I am interested, I wasn't quite sure I followed through how it had that impact on 29A.
It's the one or more.
It's the one or more instances. I think that it might help as well, I just note, and it's one of those tricks with the PID Act, is there's all these defined terms that are linked throughout the Act. So all the protection provisions that are in the PID Act, so reprisal, compensation and so forth, apply to public interest disclosure, which is defined in 26. So you go to 26 and then you're looking at satisfying, sorry, I've lost my 26.
We're in 26.
You're in 26, so it needs to be by a person who's a public official, and the recipient of as a person who's an authorised recipient, and that all the requirements set out in the column 3 are satisfied.
Yeah.
So when we're looking at internal disclosure, which is usually your first step, so the information disclosed tends to show that the one or more instances of disclosable conduct. So then you have to go to Section 29 to work out what disclosable conduct is, and it tells you it's that long list of conduct and kinds of conduct, I guess is another language in that table. So it's thinking about it as instances. And then you've got the new 29(2)A that will say personal work-related conduct is not disclosable conduct unless it's meeting those exceptions to that exclusion.
But you see, when I then go to 29A, it makes no reference back to Section 26. It just seems to have a broad and fairly unambiguously broad definition of personal work-related conduct. And so, for example, you know, if somebody is demoted and the demotion on the face of it is because they were late turning up to work for 6 months, or were cranky with their manager, or that would on the face of it amount to personal work-related conduct. How do we then go behind that and say, well, actually that all related to how they were being marginalised and responded to because of the whistleblower complaint? How do we bridge that gap through your reasoning?
So 29A is simply defining personal work-related conduct for the purposes of 29(2)A, which is excluding it from disclosable conduct. And in terms of working out whether it's then excluded, so you're looking at, is it personal work-related conduct? Okay, yes, it is. But do any of those exemptions apply to that? So is it reprisal action in relation to other disclosable conduct? Or is it of significant nature or has significant implications? But then you would bring it back in as disclosable conduct.
But none of that relates to your definition, to what you took us through in Section 26. I don't see how Section 26 helps us on this journey.
Section 26 is just illustrating that in terms of being a public interest disclosure, which is what attracts the protections, can sit underneath it more than one instance of disclosable conduct, which could be disclosable conduct, fraud, maladministration, whatever else, could be also personal work-related conduct. And so the way that 29(2)A is operating is only pulling out conduct that is personal work-related conduct from the disclosure, but not the other conduct that is disclosable.
I understand it could be a separate instance of something that's protected, but then to prove that, you have to prove either reprisal or one of the other two tests in the proposed new 2AB. And we heard from witnesses earlier that proving reprisal, getting into the mind of the person taking the adverse action, has proven to be impossible. So it doesn't really help.
I mean, in terms of getting on to allocate, like getting past having made the disclosure, the authorised officer who receives it isn't, investigating and making determinations about whether there has or hasn't been reprisal, and they can only decide not to allocate it and do nothing with it, if they're satisfied on reasonable grounds that there is no reasonable basis on which the disclosure could be considered an internal disclosure.
And Senator, if I might just add to Ms Crawford's point on that, at the stage of allocation, so at the stage that an authorised officer is considering whether an investigation should be commenced, the relevant threshold there is that the disclosure tends to show, or that the disclosure themselves reasonably believes that their disclosure tends to show that there has been reprisal action. I think the point about the difficulty in proving reprisal action, in particular to that criminal threshold, is a well-made point, and there are some amendments in the bill to address that stage of the process, sort of at the back end of an investigation where there is an allegation, a criminal allegation that there has been reprisal action. But at the point of the authorised officer making a decision as to whether or not to allocate a matter for investigation, the threshold there is simply that the disclosure tends to show, or that the disclosure reasonably believes that their disclosure tends to show that there has been reprisal action.
But both tends to show and reasonably believes are tests separate to the mindset of the whistleblower. That's a view that the authorised officer will take. And so the view that the whistleblower has that it did relate, it's the subjective view of the whistleblower, doesn't inform the decision of the authorised officer. And the Ombudsman told us that the problem is it's all going to end up in their desk if you go down this pathway.
Yes, I think the other point that's probably worth making here, Senator, just on the point of it landing on in the Ombudsman's office, and I did hear Mr Anderson's testimony earlier, the intent of the MOS recommendations and of these amendments is to allow disclosures that deal with personal work-related grievances or conduct to be investigated under frameworks that are better designed for the investigation of those processes, rather than them not being investigated at all.
Yeah, which has a systemic benefit. I get that,
yes.
Mr Reeve. There are systemic benefits to that.
Yes. So I think the question of whether or not a disclosure is going to take a matter to the Ombudsman's office because it is not being investigated under the PID Act, I think will in some significant part turn on whether an agency then is investigating that matter as a code of conduct matter, as a breach of the Discrimination Acts, as a fair matter within the Fair Work Commission's jurisdiction, Senator, under one of those other investigative frameworks.
Senator Shoebridge, I've given you a lot of indulgence because I've been very interested in your chain of questioning, of course. But Mr Reeve, you recognise that in cases such as this, there can be intertwined factors where a potential or actual whistleblower has been subject to what is defined as employer work-related conduct, but also has raised potentially legitimate concerns in good faith internally in an organisation. And one of the concerns we have is that an authorised officer receiving that initial notification simply looks at it and says, well, this is an officer who's been has a bullying complaint, and therefore that should be dealt under this stream, as opposed to being dealt with under the PID regime. Do you recognise that what I think is a legitimate concern?
Absolutely, Deputy Chair. I think what we would say is that the way the framework is set up, and this goes to the reprisal concept remaining within the scope of disclosable conduct under the Act, means that those disclosures where there is a connection between the personal work-related complaint or grievance or conduct and another substantive public interest disclosure, so fraud, misconduct, etc. Those matters can continue to be dealt with together. If there is some allegation that a person has been bullied or subject to performance management because either they have made a public interest disclosure or with the amendments contained in this bill that expand the reprisal framework to include circumstances where a person could make a public interest disclosure. That then covers the circumstance where a person has been subject to some form of bullying, harassment, undue performance management, simply because they would be in a position to make a public interest disclosure as well. So those circumstances where there is a connection between the personal work-related conduct and the balance of the public interest disclosure, focusing on those sort of integrity-related issues, the bill does permit those matters to be dealt with together. Where there is no such connection, where there is perhaps an allegation of fraud and an allegation of bullying that have no nexus to one another, those matters are the ones that would be separated and dealt with separately.
Right, but that can be very hard for especially a disclosure, a whistleblower, to demonstrate on the face of it. So, as we heard from some previous witnesses, really the onus is on the agency itself to properly record evidence with respect to workplace administrative action that's taken, performance management, etc. And that onus shouldn't be on the person who's whistleblowing or disclosing the information. So how does the bill take into account that discrepancy, if you like, in terms of the ability to demonstrate the reasons for the performance management or whatever administrative action which has been taken, where I think the onus needs to be on the agency?
No, certainly, Deputy Chair. So I think as Ms Crawford referred to previously, the basis on which an authorised officer can elect to not deal with a matter as a public interest disclosure is where there is no reasonable basis for it to be a public interest disclosure. So that's a reasonably high bar that imposes something of a bias towards dealing with matters as a public interest disclosure. Additionally, there's Section 27 of the existing Public Interest Disclosure Act that allows a disclosure to indicate that there is an associated allegation to their disclosure, and to put to the authorised officer that there are, several allegations, several instances of disclosable conduct that are related to one another. So no, I think the core of it is there is something of a bias in the Act and in the bill towards dealing with matters together, and the threshold for the authorised officer is that there is no reasonable basis to consider that the instance of personal work-related conduct is one that remains within the definition of disclosable conduct.
Okay. We haven't got much time. I've got a heap of questions, and I'm alive to the fact I need to share the call. I want to move to the exemptions to the exclusion, which are, if you refer to Clause 3 of the bill, the conduct is of such a significant nature that it would undermine public confidence in an agency or agencies, or has other significant implications for an agency or agencies, end quote. If I compare that to Clause 1.8 of the explanatory memorandum, that actually refers to, and I quote, in the context of the disclosable conduct, quote, unless it relates to systemic wrongdoing or constitutes reprisal action, end quote. So there's a disconnect or a difference, maybe it's not a disconnect, a difference, between the wording which is used in Clause 1.8 of the explanatory memorandum and the actual drafting in the bill. How did we get from systemic wrongdoing to is of such a significant nature that it would undermine public confidence in an agency or has other significant implications for an agency or agencies?
So, Deputy Chair, and I might pass to Ms Crawford if she wants to add further to my answer. I think so. Paragraph 1.6 of the explanatory memorandum, 2 paragraphs previously, sets out the actual provisions, talking through significant implications.
Yep, got that, read that.
1.8 then talks through, I think, what is an example of those limits, which is where there are systemic implications.
Okay, so well, with respect, 1.8 doesn't couch the reference to systemic wrongdoing as an example. It actually says, and this is a key interpretive document, interpretation document, it says unless it relates to systemic wrongdoing or constitutes reprisal action. So reprisal action is dealt with in Clause 2A, subclause A, and therefore reading it, one's left to ponder whether or not B is simply referring to systemic wrongdoing.
I think if I can add, Senator, that reference in 1.8 is really seeking to paraphrase what Moss is recommending rather than so much what is the words in the bill itself, though the bill is to give effect to the intent behind Moss's recommendation. So like the wording in the Moss review picks up to say personal work-related grievance, acknowledging it can be part of a larger systemic concern. Although I think we would say systemic issues would be an example of something that would fall under those. Paragraph B, the significant which I'm going to push it right. The significant implications is the same language that's in the Corporations Act, whistleblower, personal work-related grievance carve out there. So I think that was an alignment for that component too.
So the issue I have, right, and I served as a general counsel of a listed public company. I was the chief whistleblower officer, right, is I'm looking at that and I'm trying to, in my mind, try and interpret what that means in practice. So especially given we heard from Mr Anderson, the Ombudsman, that from the perspective of someone who's making a disclosure, they wouldn't be making the disclosure unless they thought it was of a significant nature and there was a public interest in terms of them making the disclosure, assuming they're doing it in good faith. And yet, from the position of the authorised officer who needs to consider this, they're going to be looking at the threshold that if you consider it as some sort of hierarchy, and I'm not sure that's the right way to consider it, but they'll say, well, this is disclosable conduct, but then there's employer work-related conduct. It falls in within employer work-related conduct. Is it brought back in? Is it carved in, to use Senator Shoebridge's phrase from earlier today, by reference to Roman 1 or 2 in terms of is it of such a significant nature? And I'm just not clear, to be open respectfully, with respect to what's captured by that. So systemic wrongdoing, okay, I can understand that's certainly captured by that. But the point I raised earlier was, how do you uncover systemic wrongdoing? There's always a first disclosure, and that first disclosure could be the first step on the road to discovering systemic wrongdoing. Do you understand the point?
Yes, Deputy Chair. I think I would, on that, just the very final point you raised there, obviously if a person makes a disclosure either under the PID Act or under any of the other Commonwealth frameworks that provide protections for whistleblowers, or simply as a code of conduct matter within their agency or department, that can be the first disclosure that then leads to further matters being uncovered. I entirely agree with that. On the broader question, though, of
but just before we move on from that, Mr. Reeve, this is a really important point. That, for example, if someone in a sensitive position is bullied by a senior executive in an agency, that could be totemic of a toxic culture which is impeding the flow of information to committees such as this, to directors, boards of directors, and that could have great public significance, even though, on the face of it, an authorised officer might view it as, well, this is just one isolated complaint of bullying, but it could also have, it could be of a significant nature in terms of the culture of the organisation. Do you take that point?
No, I think I do, Deputy Chair. I think you may have even preempted what I was about to turn to, which is, I think in terms of what is of a significant nature, I mean, we of course wouldn't want to try to exhaustively define that or get into hypothetical examples about a particular case. But I think, as is indicated in the explanatory memorandum, we certainly would be looking at issues that are of a systemic nature. We'd be looking at issues that affect...
Sorry to interrupt. That's not necessarily systemic, right?
No,
if you're the authorised officer considering that, it might be bullying at a very high level, yes. But if there's only one report you've received, almost by definition, that's not systemic, but it could be very material and significant. Do you understand the distinction?
We do, Deputy Chair, and I think Mr Reeve's trying to give you a list. This is only one in terms of systemic nature of the other types of conduct we think would fall within this definition without having an exhaustive list in the bill. Go for it, Parker.
So I think obviously conduct that affects sort of the management or control of an agency, which I think, to take your point, sort of that conduct at a very senior level, where the allegation of bullying or harassment could have that broader effect on an agency. Yep. I take that point. And then I think, as is set out in the bill, there's a question of whether it would affect the public confidence in the agency itself. And so again, that could go to its impact on a major program or on the delivery of services, or something of a significant nature. I think, Deputy Chair, this is an area where guidance material, that we do intend to develop in consultation with the Ombudsman, or rather, we would consult with the Ombudsman on their development of that guidance material, could do quite a bit of work. But to take your point, if the explanatory memorandum itself doesn't provide sufficient detail on that, that is also something that we could look at.
Just on that, if an authorised officer has had 5 separate complaints put before them, perhaps from 5 different employees, can the authorised officer on the 5th one have reference to facts outside of that complaint in order to satisfy themselves that it's significant? Or are they, on one reading of the bill, they're kind of trapped to look at the one instance in front of them? Which is it? Can they look at all 5? Because I think on one reading of the bill they can't. They're looking at them all discreetly. And they might fall into error if they look at the other 4 to give context at number 5.
That may seem to be an issue we want to take on notice and come back to you very quickly.
It's a complicated question.
It is.
The same question occurred to me, to be frank, in terms of, and this is one of the issues in terms of that phrase systemic, that if someone can only consider disclosures that are made on a piecemeal basis, or whether or not they can consider the impact of the aggregate. That's the issue. I'm not sure what the answer is either, but that same issue concerned me. I've only got limited time, so I'd like to quickly run through some other issues, and feel free to take some of these on notice. Both Senator Shoebridge and I were on the Joint Select Committee looking at the NAC legislation, and there were carve-outs included in terms of restrictions on disclosure for health practitioners, disclosure to health practitioners, so particularly we're concerned, especially on the testimony we received, that people in this situation can be under immense stress, psychological stress. They may well be seeing a health practitioner to obtain assistance, and whether or not that can actually be accommodated in the context of the bill. So happy for you to take that on notice unless you've got an immediate response.
Well, Deputy Chair, Mr Reeve actually developed that legislation, so I'll get him to respond to you prior to coming to their work on the PID legislation.
There you are. There's a hand pass for you, Mr Reeve.
No, precisely, Deputy Chair. So I am quite familiar with the issue you're raising, and of course the government did make amendments to that, to the NAC legislation to address that issue. That's something where we can have a look at for this bill as well.
Okay. We've received very compelling testimony today with respect to the complexity, and Ms Crawford, I think your very intelligent and articulate analysis of the clauses as you walked us through them demonstrates that we're dealing with a very complicated piece of legislation here. And I note that the second stage of reform is going to include consideration of a whistleblower protection authority, which perhaps could provide guidance, support, potentially assist someone to implement the protections against reprisals that are contained in the legislation, and indeed its mere presence could in itself assist in terms of mitigating against reprisal activity. Is it envisaged by the Attorney-General's Department that its consultation will encompass a whistleblower protection authority that would extend to both the public and private sector?
So, Deputy Chair, I'll start by saying that I think the way that it's been framed by the Attorney-General currently has been in relation to public sector whistleblower protection authority or commissioner. We'll have to take away and have a discussion with the office and the attorney the evidence that's been given today about it having a broader application.
Okay.
And how quite often it's mixed. And we heard from one of the witnesses earlier about how often that's mixed and how you would disentangle that if you only have a public service related commission. You take that on notice too?
We will. And I think it's clear, I know you're under time pressures, but the government has committed to a discussion paper about the need for it. And so we can have a look at this issue as part of that.
Okay, thank you. Maurice Blackburn in their submission referred to some of the issues that could arise in the waiver of confidentiality of disclosure identity, in particular where perhaps someone under an immense deal of pressure, personal pressure and stress, maybe confides in a trusted work colleague, and that could inadvertently lead to them compromising the ability to keep their identity confidential. Can I simply ask you to take on notice Maurice Blackburn's suggestion and provide a response to their suggestion in that respect? Are you
Yes,
able
Deputy
to do
Chair.
that?
Yes.
And finally, as I'm sure my colleagues have additional questions, I've gone through the Law Council of Australia submission, and as always, this committee takes very seriously the recommendations and suggestions from the Law Council of Australia. So can I ask you to take on notice the recommendations which they've made and to provide a response to those recommendations, if you could. Happy for you to do it in short form, but I just want to make sure that instead of me running through all of the recommendations, some of which we've already canvassed, I just want to make sure that this process includes a comprehensive response to the recommendations that have been made, suggestions from the Law Council of Australia. Could you take that on notice, Ms Moran?
Yes, Deputy Chair.
Okay, thank you very much. Thank you, Chair.
Thanks, Senator Scarr. Senator Shoebridge, you have the call.
Thanks, Chair. Before we dive back into 29A, one discrete issue that I think arose in the earlier evidence we had, and it's also picked up in the Law Council submission, and I think it's paragraph 17 of theirs. The Law Council says, in December 2020, the Australian Government indicated when responding to the Moss review that it was, the quote is, considering options for creating a list of security cleared lawyers that may be used by public officials who wish to seek legal advice in relation to information that is a national security or other protective security classification. Now, I know that that's a response from the former government, but the evidence we had was that that would be extremely helpful for whistleblowers, or for many whistleblowers, if they're concerned about a national security or other secrecy provision. Is that progressing in any way? Can you shed any light on that?
So thank you, Senator. So that is something that we are aware of from the evidence on this, and we will look at further. I think in relation to some of the evidence today around the publishing that list of lawyers with security clearances, I would want to note, I think the Director General of Security's statement in his annual threat assessment last week around the risks of publishing the identities of security clearance holders. I think there is a balance to be struck there between providing that transparency around who a person might go to without sort of identifying that person as someone who may hold classified information. So that's just a point I'd just want to flag immediately on that issue, Senator. But that's something we can look at further.
Well, I mean, if there's a balance there, at the moment the balance is harming whistleblowers because they don't know where to go to get legal advice. And is the impact of the whistleblowers, harm caused to whistleblowers who just don't know where to go to get legal advice, how is that weighing up in those considerations?
No, Senator, I take the point. I think, and it depends sort of where an official is working, but particularly in those agencies working in quite high security environments where this issue is most likely to arise. That's an issue that a lot of those agencies do have procedures and policies in place to pair up their staff with external legal representation with appropriate security clearances where that is required. And that is not limited to the public interest disclosure framework, obviously. Yeah. It relates to sort of employment matters and the like as well. So I wouldn't want there to be an impression that there are no arrangements in place. That is generally handled at the agency level or in consultation with external agencies as well.
Well, you don't have to necessarily whack it up on the Attorney General's website in order to have the information go where it needs to go. But if across the public service, if people who have security clearance and access to top secret information, if they also had access to the list of lawyers that could help them, if they had a problem, a whistleblowing problem in relation to that information, that seems to me to be an achievable resolution of those two conflicts, so that you don't just simply leave it up to the agencies, case by case, to maybe or maybe not implement that.
And Senator Shoebridge, just adding to what Mr Reeves said, I think we are thinking about the options for how you deal with it, noting the comments from the Director-General. We had in our head that this would be part of the Stage 2 reforms to deal with the issue of legal advisors more generally.
But it doesn't seem to require a legislative reform. If there was a directive across agencies to say, if you have this level of clearance, you also have access to a list of lawyers who can help you out if you've got a problem, that doesn't seem to require 12 to 18 months of considered interdepartmental review, and that seems to be something that could be implemented quite easily.
We can take that on board, Senator Shoebridge.
Could I go back to the, I'm not quite sure if we call it a carve-out or an exemption to a carve-out, but the 29A, we'll call the 29A a carve-out, and then we can call 29.2A an exemption. Going forward, that might work, unless you've got a better term. So going to the carve-out in the proposed new 29A, do I understand it was the intention of the drafters that it only cover personal work-related conduct where it's solely in relation to personal work-related conduct? That was the intention.
That's correct.
Yep. And if that's the intention, could you take on board whether or not there might be some merit in just unambiguously legislating that, not with an explanatory note, but actually just unambiguously saying solely, and to be consistent with recommendation 5?
What I'll say, Senator Shoebridge, is we've heard the evidence today, and what we will do is have a look at that exact point.
Yep.
What I can't commit to is saying that we will include the word solely in the bill.
Yep. I'm not asking you to say, yep, we're going to sort it and amend it. I know that there's a couple of steps to go through.
Thanks.
But if we're looking to the Corporations Act as kind of an example, or perhaps at least partly the model you used for this, and do I understand that is the case? You look to the Corporations Act as partly a model? Do you accept, though, that one of the fundamental differences between the two is when we're talking about establishing reprisal action, that I think it's section 1317AD in the Corporations Act has a reverse onus for particularly that critical element of the offence, which is the subjective intention of the person taking the reprisal action. The onus is on the agency or the corporation to disprove the reason. And that's a critical difference between the two schemes, isn't it?
Yes, that is a difference at the moment, Senator.
And that means having a reprisal a reprisal exemption to the carve-out in the PID Act is very, very different to having it in the Corporations Act. Because in the Corporations Act, the whistleblower has the benefit of the reverse onus, that the corporation has to disprove the reason. Whereas there's no such benefit for the whistleblower in the PID Act, is there, Ms Crawford?
When you get to the point of proof, and we've made some changes to the offence provision for reprisal offence in this bill that does have a shifting onus in terms of the reasonable administrative action, which is different to the definition of takes a reprisal, which is in section 13. I guess the observation to sort of make, it goes to some of our earlier evidence as well, is in terms of, I guess, the allocating the treating of the disclosure by the agency is not going to that beyond reasonable doubt proof benefit. And again, it's sort of pointed to in section 43, that authorised officer just has to be satisfied on, or has to be satisfied on reasonable grounds. There's no reasonable basis it could be an internal disclosure. And as Mr Reeves said, that's quite a high bar, so I wouldn't have see it as needing to go down to sort of proving that sort of state of mind. If there is a suggestion that it is a reprisal action, would expect it to carry through and be treated as a PID.
But it's still an objective determination by the authorised officer in Section 40, under Section 43. And the very passionate belief that the whistleblower, that they're connected, that the reprisal action is connected to whistleblowing, is not going to satisfy an objective test, is it?
That will depend on the nature of the disclosure and the information given at the time.
But you agree it's an objective test? Although at a lower threshold, it's an objective test in Section 43 for the authorised officer.
Yes.
Sorry. Yep. And if it's an objective test, they're going to go and have a look and see, can a critical element be evidenced? Is there evidence of a critical element? And one of the critical elements is, even under the amended Section 13, Section 13(1)(c), whether or not there was the belief or suspicion was the reason or part of the reason, and the belief or suspicion here being the making of a whistleblower complaint, whether or not that was a reason or part of the reason. And how do you prove, how is an authorised officer ever going to be satisfied on any kind of objective basis what's in the mind of the person taking the reprisal action? We heard from Mr Whealy here that it's impossible. Has that been improved in any way in this bill?
So, Senator, this bill doesn't
I don't know what
amend...
you're thinking, Mr Reeve, for example.
So, Senator, I mean, this bill is implementing a number of the priority recommendations from the Moss review. The bill does make a number of amendments to the reprisal framework, as Ms Crawford has outlined, but you're correct, it does not adopt the Corporations Act framework for reversing that element of the burden of proof. It does reverse the element of other elements of the offence.
But that's the most critical one, isn't it, when in terms of reverse onus? Because the only person who can really give evidence about what's in the decision maker's mind is the decision maker. And that's why the reverse onus lies in the Corporations Act. But for some reason, that hasn't been included in this these amendments. So first of all, do you agree the only person who can really give credible evidence about what's in someone's mind is the person themselves? Unless they've, written a note, I'm doing this because I'm mean and wanted to have an action against a whistleblower. That's why we have a reverse onus.
Senator, I'm not sure I would agree with that entirely. I think as Mr Anderson gave evidence on earlier today, the documentary record inside an agency may allow inferences to be drawn and may point to one way or the other, in particular where the performance management or other conduct only commenced after a public interest disclosure is made, for example. But sort of more broadly on the sort of the architecture and structure of the reprisal offences, as with many other parts of the PID Act, the government has committed to the second stage of reforms.
But you see, without that second stage, the broad exemption that's proposed in Section 29A has a really potentially unintended breadth of reach. Without having done that other work and fixed the reverse onus, made it easier to prove reprisal action, without having done that, 29A as drafted has potential overreach, doesn't it? And excludes things from that might otherwise be legitimately included within the PID Act.
Senator, I think we probably can't go much further beyond the evidence we've given on the high bar for an authorised officer to form a view that there is no reasonable basis on which the disclosure could be a public interest disclosure, and the threshold for that being that the evidence tends to show that there has been reprisal action, or that the discloser themselves reasonably believes that the evidence tends to show that there has been reprisal action.
But the critical thing that's going to be missing 99 times in 100 is any evidence about the belief or suspicion of the officer taking the alleged reprisal action. That's why the reverse onus exists in the Corporations Act, isn't it, Mr Reeve? Because it's so hard to prove.
Senator, I probably couldn't comment on the Corporations Act itself, but the Corporations Act certainly reverses the onus of proof.
Yeah. Well, Ms Crawford, you said, I think it was you, who said that some of this drafting is to reflect how the Corporations Act worked. So when you were looking at the whistleblower provisions of the Corps Act, there must have been some consideration about whether or not the reverse onus would be included in this raft of reforms. What was there?
I was looked at, Senator, but given the complexities in amongst all of that and looking at the protections framework as a whole, considered in the second stage more so, while this one's focused at the Moss recommendations themselves.
All right.
The other thing I'd just maybe add, if it's helpful, is and the role of the authorised officer is not to investigate the disclosure and make findings about whether it is or isn't reprisal action. The role is to determine whether the appropriate place is to allocate or not allocate that disclosure. So again, as Mr. Reeve pointed out, the tends to show language in the definition of public interest disclosure, the on reasonable basis. It's not making a conclusive finding at that stage.
Did anyone ever try and do a flow chart of how these decisions are made within the AG's department?
I think we have a lot of flow charts, Senator.
Could you, on notice, provide a flow chart of how these decisions happen?
Or multiple?
We can take that on notice, Senator. See which ones we already have.
Yeah, because as I see it, if this gets legislated in its current form, it's going to be a question of, I don't know whether it's snakes and ladders or some kind of sewerage plumbing diagram, but it's going to be very hard to follow without some kind of, the polite term I'm going to use is flow chart for decision makers. So could you provide one on notice?
We'll take that on notice, Senator Shoebridge. And I know Mr Anderson said earlier, and Mr Reeve has also mentioned it, but we will be working with the Ombudsman's Office on guidance to agencies around how these new provisions operate.
Look, I'll finally ask this. You must have known when you're going through this process that there are many people who are concerned about becoming whistleblowers because they fear criminal prosecution. And, we've got the cases of outstanding cases against key whistleblowers like David McBride or Mr Boyle. You must have known that putting in more legal complexity could potentially send a signal to other potential whistleblowers not to go down that path because it's a minefield already. Did you take into account the potential damage of even more legal complexity in this space when drafting these provisions?
Well, Senator, I might start and then let Ms Crawford and Mr Reeve supplement. But I think it's always our intention when we draft legislation to make it as simple as possible. So we haven't intentionally drafted a bill that adds complexity is what I
wasn't
would say.
saying that, Ms Moran. It was more the other side. The impact of complexity, and because it does make it more complex, this bill. Did you take into account the impact of more complexity?
I think that the amendments that we've made at this point, as we've said, are the priority amendments to respond to Moss and the other two parliamentary committees. And the overarching complexity of the scheme is not lost on us, and we are hoping to address that in the Stage 2 reforms, Senator.
And it would be remiss of me not to ask about resourcing to the Ombudsman. We had the Ombudsman's Office here concerned about resourcing issues, concerned that they're given more tasks, some of which, in terms of looking at reporting, I think they welcome, some of which they potentially don't welcome. Has there been a discussion or a commitment to provide more funding to the Ombudsman?
So, Senator, I'll just echo what the Ombudsman said, which is he's in discussions with the Attorney-General's Department about their resourcing needs, and that decisions around their resourcing is ultimately a matter for government.
Thank you, Senator Shoebridge. I have some questions if you are ready to give up all. Thank you, appreciate that. Thank you for your evidence and thank you for your submission. It's been really helpful. I just want to go through a couple of the things picked up in your submission and raised by some of the witnesses today. The issue around personal work-related conduct, that's obviously been a theme throughout today, but also through the submissions. Can you just explain pretty plainly for the committee, why does the bill remove personal work-related conduct from the scope of the Act? And what is we've talked a bit about the Corporations Act and the difference in the wording there. Why has there been a deliberate choice to use the word conduct instead of grievance?
I'll start while Ms Crawford's finding her paperwork, but at the simplest level, Chair, the reason the carve-out exists is to respond to recommendations 5, 6 and 7 of the Moss Review.
In terms of the drafting language for personal work-related conduct rather than grievance, as sort of mentioned earlier, conduct is fitting in with the terminology already used in the Public Interest Disclosure Act, so it's really a drafting decision. It already talks about disclosable conduct, so it makes sense to talk in terms of conduct. By contrast, the Corporations Act just doesn't have a conduct concept in it at all. It's a disclosure of information, so it's why it has picked up the grievance language there. And I believe there's a concern that actually grievance may be less clear in terms of being able to confine it to particular one or more instances to fit in with the drafting of the Act.
Okay. One thing we haven't touched on too much in our conversations today, but I know is an issue around sexual harassment and other unlawful forms of discrimination. Will they be covered by the PID Act going forward, and what's the rationale behind how those matters should be dealt with?
Thank you, Chair. So obviously bullying, harassment and sexual harassment in particular are very serious matters, and the amendments around personal work-related conduct in the Act are in no way intended to suggest or provide that those allegations of that nature should not be investigated. However, I think as the Moss Review itself noted, the overlaying of the process requirements in the Public Interest Disclosure Act onto the investigation of personal work-related conduct, including bullying and harassment and including sexual harassment, can prevent agencies from applying best practices approaches to resolving those issues and prolong disclosures' exposure to the situations that they are in and the conduct that they are suffering. And I think as the Public Service Commission gave evidence on, the standard timelines in the Public Interest Disclosure Act can take up to 104 days to go through, which in those contexts can delay the resolution of those matters. In relation to sexual harassment specifically, the Sex Discrimination Act contains detailed protections for people who make allegations of sexual harassment, including protections against victimisation where they make those complaints. So, Chair, to the extent that a complaint of sexual harassment is not covered by the Public Interest Disclosure Act because it is personal work-related conduct, those protections under the Sex Discrimination Act could apply.
Okay. Another issue that's been raised by some of the submissions, not really the evidence that we've heard today, but is how we're sort of going to deal with parliamentarians and their staff going forward. I know there's been a lot of work done through Set the Standard and a lot of work, it has to be said, to implement those recommendations. And I think we're almost getting to the point where a lot or most of those recommendations have been implemented, which is fantastic. Why does the bill expressly exclude parliamentarians and their staff from the scope? And in terms of recommendation 23 of Set the Standard, which does relate to improving whistleblower protections, how is the government dealing with that recommendation? It's a two-part question there, sorry, but I thought...
So, Chair, I might kick off and then have my colleagues jump in if I've missed anything. I think primarily with this bill, what is being implemented is recommendation 26 of the Moss Review, which recommended expressly excluding parliamentarians and their staff from the operation of the scheme, which was, at the time it was drafted, the policy intention. I think you know the PID Act was designed to operate within the public sector agencies and wasn't designed to apply to parliamentarians or their staff. And so this amendment is making that abundantly clear on the face of the legislation. is the first part of your question. The second part goes to what's happening in relation to set the standard, and you'd appreciate that that's not work that we are leading, Chair, but there is a task force set up in the Department of the Prime Minister and Cabinet who are leading on the implementation of the government's recommendations. There are a couple of things I would mention. Earlier you asked the APSC about the PWSS, the Parliamentary Workplace Support Service, and so that is an independent complaints mechanism that was established following the Foster Review, and is a new complaints mechanism that's independent and is doing, from previous work experience, very good work for parliamentarians and their staff to be able to take to that independent mechanism complaints and allegations of misconduct and wrongdoing, which did not exist at the time that the PID Act was put in place. Equally, Recommendation 23 has been partially implemented by government by ensuring that there are adequate and strong protections for staff of parliamentarians if they make a disclosure to the NAC, and the protections in relation to doing that are very similar, if not the same, to those contained in the PID Act. I also understand that there is still work ongoing, Chair, in relation to whether or not further protections are needed in relation to development of the Independent Parliamentary Standards Commission, and that's work that is currently underway. I hope that answers your question.
Yeah, it does. Just in terms of set the standard, that leads me into, I guess, a broader question. A number of witnesses today have raised the prospect of further reforms, and we know that this piece of legislation is occurring in an environment where we've got the National Anti-Corruption Commission legislation and the establishment of that body. We've got other reviews, I think, into secrecy laws happening, and it's been flagged by the Attorney General that there'll be a broader stage of, well, a proposed broader stage 2 reform process. I just wondered whether you might be able to explain, or what information you have already about that work that's underway, what that work will be consisting of, and how the development of those further proposals sort of feed into this piece of legislation being almost the first step that's needed to then inform the rest of the proposals.
Thanks, Chair. Again, I might start, and please jump in. I think what I would say is that we see this bill at the initial stage of it as being one aspect of the broader government integrity agenda and an uplift in that space. And so these priority amendments will complement and support the broader integrity agenda, which is a kind of an immediate aspect, and ideally these amendments will come into play at the same time as the National Anti-Corruption Commission ideally will kick off. As you've mentioned, there are a range of initiatives underway, some of which you've talked about, but there are others ongoing, and we are in sort of close discussions with a range of different departments who are leading different parts of this integrity agenda, and so some of them, and a bulk of them, do sit within the Attorney General's department and within our division, and that goes to the establishment of the NAC, introducing an amendment to the fraud rule under the PGPA Act to add corruption into that, and requiring agencies to take steps to prevent and detect and deal with corruption. I think you know that in the Attorney General's portfolio as well, we've just closed a discussion paper in relation to a federal judicial commission. There's a range of work happening in relation to the appointments process and ensuring that that's a kind of transparent and merit-based process. We work with the APSC in terms of the work that they're doing in this space, but also the APS Reform Office in Prime Minister and Cabinet. And then there's also the bulk of work, I think, in relation to set the standard. And so we're seeing stage 1 as having a kind of immediate impact, but then stage 2 dealing with, as I said earlier, the complexity of the overarching scheme, but looking at it, the PID Act scheme in the context of what is now kind of a range of additional infrastructure that was not in place when the PID Act was initially passed by the Parliament. Have I missed anything? Is that answer? I hope that answers the question.
Yeah, and look, this is just my final question, and I think Senator Shoebridge has a follow-up around the interaction with the PID Act and the National Anti-Corruption Commission. There's been sort of public calls for the public interest disclosure whistleblower provisions to be implemented as soon as possible, because the National Anti-Corruption Commission will be up and running fairly soon, hopefully. What's the relationship with getting these reforms through in time for the Commission to be established, and why is that so important to do together?
Thank you, Chair. I think perhaps to start with the last part of your question first as to the importance of these reforms, I think it hopefully goes without saying, but perhaps for Hansard's benefit at least, that obviously the National Anti-Corruption Commission will benefit from whistleblowers bringing forward allegations of serious or systemic corruption in the Commonwealth public sector, and sort of a free flow of those disclosures, or under that framework, referrals to the Commission is important for its functioning. And so it is important that there are strong protections for people who make referrals to the Commission. The National Anti-Corruption Commission Act contains a number of strong protections for people making referrals that are modelled on the Public Interest Disclosure Act. This bill makes a number of amendments and implements a number of the Moss Review recommendations to further strengthen those protections and applies those back to the National Anti-Corruption Commission.
Okay, thank you. I think that was important to understand. Senator Shoebridge, you said that you have a follow-up question.
I do, but just on that last point, Mr. Reeve, getting this right before the NAC opens its doors is actually critical, isn't it? Getting the whistleblower protections right before the National Anti-Corruption Commission opens its doors is one of the drivers for dealing with it so quickly. Is that right?
Yes,
Yep.
Senator.
So then, if there's an inadvertent negative impact on whistleblower protections, and here I suppose I'm particularly focused on carving out those mixed employment grievance whistleblower matters, if we get that wrong before the NAC opens its door, well, that'll have quite serious negative consequences on the NAC, won't it, if whistleblowers don't feel free to come forward?
I think on that point, Senator, the protections in the National Anti-Corruption Commission Act apply to any person who provides the National Anti-Corruption Commission with information in relation to serious or systemic corruption. Those protections in the NAC Act do operate independently of those within the PID Act, so the amendments around personal work-related conduct in no way limit the operation of the NAC Act in that respect.
But that's also missing any of those reverse onus provisions to prove intent, to prove the rationale of the reprisal action. That's also barren of any of those reverse onus provisions, the NAC legislation, isn't it?
I think, yes, the provisions in the NAC legislation do align with those in the PID Act in that regard.
I note that when you were discussing the implementation of Recommendation 26 of the Moss Review, when you were discussing it with the Chair, which is about not having the PID apply to alleged wrongdoing by senators, members and their staff, your answer, as I understand it, is you think that's largely being dealt with by PWSS at the moment?
No, Senator. What I was suggesting is the Chair asked a two-part question. Mm-hmm. One was, why have we put the amendment in to be explicit in the legislation that it doesn't apply, the protections don't apply to MOPSAC staff and parliamentarians? And my first response was that we were responding to Recommendation 26. The second part of the question was what was more broadly happening in the parliamentary space. And so then I went on to say there are a range of things happening that I understand, and I said one of them was that there was a PWSS in place, and that happened in response to the Foster report. That there's now the NAC legislation that's passed, which will include protections for MOP staff who make a disclosure to the NAC, And the third part of it is that I understand, as part of the development of the Independent Parliamentary Standards Commission, there is further work going on in relation to protections for disclosures under that provision.
Right. Then where does that leave recommendation 27 from the Moss Review, which is that consideration be given to extending the application of the PID Act to members of Parliament or their staff if an independent body with the power to scrutinise their conduct is created?
In relation to that, I think our ideal is that we will have a look at this broader application as part of stage 2 of our reforms.
And that would include potentially extending the PID Act to cover those members of staff and then potentially operationalising that through one of those agencies.
I think there are a number of options or models to work through with new infrastructure in place, like a National Anti-Corruption Commission or an Independent Parliamentary Standards Commission, which at the time of these 2 recommendations didn't exist, Senator.
Yeah. Do you accept, though, that one of the benefits of extending the PID Act to members of Parliament staff is that's consistent with the no wrong door approach? That if there's a whistleblower and concerns being raised, there should be no wrong door. And that's one of the benefits of extending the PID Act to members of Parliament staff.
Senator, I think what we'd say is we along with our colleagues in Department of Prime Minister and Cabinet, are looking at the application of these different bodies and models to MOPSAC staff.
All right. Thanks, Chair.
Thank you, Senator Scar. You don't have any other questions?
No, I'm done. Thank you, Chair.
Okay, thank you very much. Thank you to the representatives from the Attorney General's Department. That concludes our hearing today. I don't think we've had any tabled documents, but for the purpose of questions on notice, just seek to move a motion from Senator Scar to determine a deadline for returning answers to questions taken on notice for the Friday the 3rd of March 2023.
Yep.
The committee has agreed that answers to questions on notice should be returned by that close of business on that day. I thank all witnesses who have given evidence to the committee today. Thank you also to Hansard Broadcasting and the Secretariat. I declare the hearing adjourned.
Thanks, Chair.
Thank you.